is an appeal in the matter of Aina Limited and Legal Ombudsman.
Yes, Mr. Cosman. We've read the papers. There is really only one issue. This is not a state trial, and this appeal will be done today. Okay? Far away.
I appear for the Legal Ombudsman. My learned friends, Ms. Linfield and Ms. Tariq, appear for the Respondent.
Yeah.
I apologise at the outset for the issues with the papers and the bundles. I'll endeavour to ensure that all paid references are to the bundles that you have, rather than bundles I've put you up. You ought to have, my lords, a core bundle of 326 pages, a supplementary bundle of 361 printed pages. There's a slight discrepancy with the PDF, but it appears that Coulson is working exclusively from paper, so that needs to take.
So that's one thing you don't have to worry about.
Yes. Thank you, Lionel. There is a bundle of authorities of 735 pages.
Yeah.
And then there is a short, what's called further supplementary bundle that went in at the tail end of last week with basically 3 categories of documents. The first was an appendix to the Statement of Facts and Grounds. The second category of documents are the cost schedules below. And the third was our cost schedule for the purpose of this appeal. And I understand that subsequently yesterday 2 further documents have been added. I learned a friend's client's cost schedule, and additionally an email was sent by counsel to the judge below concerning the content of the then draft judgment. I wasn't entirely clear as to why that had been put in, but we've agreed that I'll address it in reply.
Okay.
My lord, you will have before you the key documents in the core bundle, of which the 2 most important, of course, are the judgment at Tab 5 and the decision. And by decision, I refer to both the final decision and the revised provisional decision that it adopted at Tab 13. If you're working from tabs, I understand that my clerks delivered tabs to you, so hopefully tab references can now work. If I can just get page 1, that'd be easier.
Well, I haven't got tabs in the course, but that's all right because I flagged them up.
Well, for pages, judgment, page 51, decisions, page 217 and on. The parties have agreed to split time. We'll obviously have to revise that slightly in light of your indication this morning, my lord. It sounds like I will have to be wrapped up by lunchtime or very shortly thereafter for that to work.
Yeah.
I'll endeavour to do so. And then finally, by way of procedural matters, below an anonymity order was made, that supplementary bundle, tab 41, page 326, by which the interested parties named and noted her children withheld in the proceedings, and a cipher, CXV, has been used for them.
Yeah.
Whilst I'm not sure technically confined to this court, I intend to continue to maintain the use of that cipher.
Well, for the avoidance of doubt, I'll make an order. I make an order now that the anonymity order is continued.
So as the order of my submissions, they will be as follows. First, the relevant legal background to grounds 1 to 3. Second, the underlying facts relating to grounds 1 to 3. My lord, I'm mindful of your statement at the outset. This is not a rehearsal or a rehash of the facts in issue, but I do need to delve into them briefly. The third limb will be then the submissions on each of grounds 1 to 3, and it's in that context I'll take you to the relevant passages of the decision. And then finally, ground 4, the cost ground.
Yeah.
Well, if I may just briefly outline sort of the genesis of the appeal, as it were, just so that as I kick off on the law, you have it. The appeal concerns a claim brought by Aina Limited challenging the lawfulness of a decision of the Ombudsman Andrea Vaughan, dated the 12th of February. The decision concerned a complaint brought by the interested party on the 28th of October 2021. For this appeal's purposes, the principal issues the Ombudsman determined related to costs charged by the respondent to the interested party in late 2020. The Ombudsman's decision adopted in large part her earlier revised provisional decision at page 217 of the core bundle, and she determined the complaint in part, and for our purposes in material part, in the interested party's favour. Her remedy was set out in the final decision at page 246 of the core bundle in two clear parts. First, a fee refund of £35,500 said expressly to be related to the firm's failure to notify and get agreement of costs. And secondly, a 20% fee reduction of £15,692.60 to recognise that CXV did not have capacity to act. And I'll go to first the latter, which is of course the element of the remedy that is in fact an issue, as the fee reduction, in contrast to the fee refund. The fee refund was the subject.
So the appeal is concerned with the fee reduction of £15,692,
In essence,
which is another reason why it'll be done today.
exactly. So the fee refund, the 35,000, the greater figure, was the subject of a cross appeal, which was refused permission.
Yeah.
So the claim itself was issued on the 9th of May. There were 5 grounds of challenge. And on the 25th of on the 25th of November 2024, Vikram Sachdeva, sitting as Deputy High Court Judge, permitted 3 grounds. The other 2 grounds were refused permission and no application was made to renew them, and he also refused injunctive relief. For your note, that order is core bundle, page 156. The substantive hearing of the claim was then listed before Mr. David Pievsky KC, sitting as a Deputy High Court Judge, on the 6th of March 2025. But regrettably, that hearing had to be adjourned following both, first, multiple very late.
Well, do we mind about the procedural background?
We're worried about that one because it goes to ground 4.
Yeah,
It's set out in the judge's judgment anyway.
In which case I didn't say on that. But the effect of those procedural.
the whole thing has taken years and years, which is supposed to be a quick remedy.
Yes, my
I
lord.
appreciate the court service may have played a part in the subsequent delay, but not in the first part of the delay.
Yes, my lord. In which case, all I need note is that the substantive hearing was relisted for the 12th of May. Judgment followed just over 2 weeks later.
Yeah.
So then, turning to the relevant legal background, we've addressed this in our skeleton argument at paragraphs 17 to 26, insofar as it's common to the first 3 grounds.
There doesn't seem to be much disagreement between you. Is that fair to say, as to the legal background?
I think that's probably right. My learned friend's skeleton argument is somewhat proof in that, but I'll address, if I may, just 6 headline points.
So we've now moved to the first of the relevant legal background.
Exactly.
Yeah, thank you.
I should just say this will be made up of 2 parts. The first part concerns the statutory scheme.
Sorry, the first one is
Concerns the statutory scheme governing the legal ombudsman. I'll address capacity very briefly because, my lord, I know that both Lord Justice Coulson and Lord Justice Baker were in and determined the recent case of Johnston. So the law of capacity is, in that sense, not really up for grabs, nor is it in dispute for these.
So the first part is the statutory scheme, and the second part is.
It's going to be on capacity.
Oh, I see.
Which
Fine.
I'll
Thank you.
take
Yeah.
fair.
Okay.
So, the legal ombudsman was established pursuant to Part 6 of the Legal Services Act. Section 115 sub 1 enabled the Office for Legal Complaints to make scheme rules under authority of page 24.
sorry, page.
24, my lord.
And this is paragraph which of your skeleton?
17 onwards, isn't it?
17. Thank you so much. Yeah.
So section 1151 permitted scheme rules to be made. There's further provision for that at section 133, page 31. We have those scheme rules in the iteration relevant to the appeal. They get periodically updated in the authorities bundle at page 657. And to the extent necessary, as I go through the scheme, I'll address those together with the statute. 6 headline points. The first, by section 1131, Parliament designed the scheme so as to enable an independent legal ombudsman to resolve complaints quickly and with minimum formality. That's page 23 of the bundle of authorities for section 1131. And so legalism and formalism are to be rejected. 2 sort of subsidiary points off that. First, that language of quick and minimum formality is identical to section 2251 of FISMA, the Financial Services and Markets Act, which governs the financial ombudsman service. That's in the bundle of authorities, page 4. And so the case law concerning the financial ombudsman service applies by way of very close analogy, we say, to the legal ombudsman. And the second subsidiary point is that there is considerable significance to Parliament having chosen to describe the legal ombudsman's role as one to be discharged quickly and with minimum formality. That was an approach that Parliament plainly considered to be an important and thoroughly sensible feature of the legal ombudsman scheme. My Lords, if I could ask you to turn up the case of Maxwell in the Office of the Independent Adjudicator, bundle of authorities, page 181. And the relevant section that I would invite you to consider is at page 191 to 2, paragraphs 32 to 33 of Lord Justice Murray's judgment.
I'm so sorry. Could you just get that paragraph under again?
Paragraphs 32 to 33
Thank you.
at the bottom of page 191.
Thank you.
Just invite you to read those. And then, my Lords, when you're ready, final sentence of paragraph 34 and paragraph 38.
I'm just going to have to text my clerk, Mr. Copper, because the bundle's collapsed, so I'm going to ask you to bring it all back.
I'm so sorry, my Lord. If it assists, I have a
No,
spare bundle of authorities.
No, I've already marked this one, so I'd rather keep this one. Don't worry, carry on.
It's a while since I looked at this scheme. Did it carry with it a duty to give reasons for the decision?
The Office of Independent. Well, I'll have to come back to that.
And likewise, when we come to the instant scheme in this case, did it carry with it a duty to give reasons?
There's not an express statutory obligation to give reasons.
So any duty to give reasons would be an expression of fairness.
Exactly.
Right.
But it would not be a purely common law fairness inquiry insofar as it would be shaped
By the statutory scheme.
Exactly.
But it's not a Reinhold type duty to give for reasons, is it?
My Lord, perhaps I can put it this way. There is a duty to give reasons that accord with the obligation or the structure that Parliament chose to set
Yeah,
up.
you've said that.
Yeah.
But I'm just wondering to what extent it would be appropriate to invoke the principles we see in Say and South Bucks, where you have to deal with the principal important controversial issues. That sort of formulation sounds as if it's addressing an adversarial system whereas you're pointing out this is inquisitorial.
Yes, my lord. So I'll come, if I may, to reasons in just a moment, because there is case law on
Okay.
what they are and what they have to be.
Yeah.
Um,
I asked the question partly because you can see at the end of 33 the distinction is being drawn with judicial decision making where the Reinhold and Emery approach applies. And therefore querying to what extent that's appropriate when you're dealing with this sort of scheme.
so, my lord, I'll just I'll take this now, if I may.
Yeah.
Parliament constructed the Legal Ombudsman scheme in order to resolve complaints.
Yeah.
In the manner that it states. We say it's appropriate, therefore, when considering the level of reasoning that has to be set out, to have regard to what a court is obliged to do, because whatever the Legal Ombudsman is required to do is something less than that.
Yeah.
And the clearest articulation of what a court is required to do is in the judgment of Lord Justice Lewison in the Fage and Shabani case, at Vulnerable Authorities, page 263, but actually the relevant passage is paragraph 115 at 296.
Well, that's a well understood passage.
Exactly.
It's far yea, by the way.
Well, that's my yogurt pop tells me every morning, my lord.
It's
the Greek.
exactly.
It's what?
It's far yea. All the yogurt pots say on them, if you buy it, if the Lord buys a pot of yogurt made by Farrier, you will find it says pronounced Farrier on the pot.
It is.
And yours is the same. With the same
All
breakfast.
All those times that I've said, as Lord Justice Lewison said in Fage, the trial is not a dress rehearsal, it's the first and last night of the show. I was wrong. It's
No, you're right. The
how do
citation.
I say it? How do I say it?
Far yea.
Far ye.
The citation was right, my lord.
Well, there we are.
Not the pronunciation.
I've learned something.
Yes, my lord.
Yeah. So, but you're relying on the passage at 296, which is the familiar.
Page 115. So paragraph 115. Exactly, my lord.
Yeah.
So we say that is the counterpoint against which Parliament has constructed this scheme. And so we said that the section 113 bears on the Ombudsman's decision two ways. The level of legalism and formalism with which decisions are to be read, the interpretation issue, and secondly, the nature of the reasons the Ombudsman has to set out by law observation of remedy.
But is there any authority which gives more direct guidance on what you'd expect for reasoning in an ombudsman scheme?
Well, there are.
That might be rather more helpful.
In which case, my lord, in relation to the legal ombudsman, there is the Crawford case,
Yep.
paragraph 25 that we quote in our skeleton argument at paragraph 19.
So,
And then in the context of the financial ombudsman service, as I say, it's the sister scheme, two references, my lord. Mrs. Justice Heather Williams's judgment in the Charles Street number 2 case, Bundle of Authorities, pages 443 to 444, paragraphs 20 and 21. And if you want a further reference, there's the very recent Leonard Elmas case, also concerning the Financial Ombudsman Service, Bundle of Authorities, page 588, paragraph 55.
All those are High Court cases, are they?
Those are High Court cases.
Not been approved or considered by this court.
Well, a separate but closely related issue has been considered by this court, which is when the Ombudsman is applying their fair and reasonable jurisdiction in a manner that a court would not regard to be the law, the level of reasoning that is required there. And one might think that that is effectively the high point.
is that when you're departing from the law?
When departing from
Yeah.
the law. So we would say that is obviously the high point in terms of.
Well, you've got to
the reason
have
that
presumably a level of reasoning which is sufficient for that particular purpose,
Exactly.
which is rather more specific.
Exactly. So
What's the Court of Appeal authority for that?
you have Heathermore and Edgecombe and options. And if I may, I'll turn
We're going to come to those anyway. Okay, we'll take your own time.
The others, such as the Charles Street securities that you asked us to look at, I mean, that's all standard stuff, common sense, not statutes. not legal documents, read as a whole, not in a legalistic way. I mean, no different effectively to a planning decision.
Well, it does.
That's a loaded point.
Well, it may be more similar, in fact, to a planning policy, I think, rather than a planning decision. In the sense of policies are always not to be read in a overly prescriptive manner, not like statute. So,
Yes,
so
all of that.
planning decisions may require a slightly more level of concrete reasoning. But yeah, the language used in the case law is similar to the language used in relation to
Yeah.
Tesco and Dundee, Tesco and Sainsbury's, those sorts of cases. The second headline point is that Parliament set out the jurisdiction of the Legal Ombudsman, principally at sections 125 to 128 of Part 6, which are augmented by the scheme rules. No jurisdictional challenge is relevant to us today, so I just flagged that.
Sorry, can you say that again?
Sorry, sections 125 to 128 of Part 6
Yeah.
set out the jurisdiction of the Legal Ombudsman, which is then augmented by the scheme rules.
Yeah.
In broad summary, Parliament provided in section 1251 that a complaint is only jurisdiction if it relates to an act or omission of a respondent, and it's not excluded by the provisions. Then the scheme rules.
But there isn't a jurisdiction point here.
Well, I don't think there is. My learned friend skeleton argument appears to make a point about the fact that this is paragraph 45.
Well, does the judge address a jurisdictional argument?
No, my lord.
No, well, then
Good. In which case we can move on to my third point.
we're just here to see whether the judge was right or wrong. Think of us as VAR.
My lord, it's somewhat disputed.
I mean, it may be that at the end of the day we could say, after review, I'll give the answer. Sadly, we can't, but that's what we're here for.
Yes, my lord. Well,
Yeah, 3.
third headline point. Section 137.1, Bundle Authorities, page 34. Parliament expressly specified the test to be applied by an ombudsman when determining a complaint is what is, in the subjective opinion of the ombudsman, making a determination fair and reasonable in all the circumstances of the case, and the weight of the many authorities considering the fair and reasonable test in the context of both the Legal Ombudsman and the Financial Ombudsman Service pull in a single direction. The Ombudsman has been permitted by Parliament to be subjective in his or her decision making, and accordingly the threshold for the court to intervene is very high. Nothing short of Wednesbury unreasonableness will do. Well, just to go into that in slightly more detail so you have some references. Section 137.1, as I said, page 34 of Bundle Authorities. The related provisions in the scheme rules are 5.36 and 5.37 in the Bundle Authorities at page 677, of which 5.37 sets out a list of mandatory considerations bearing on the fair and reasonable test. But it expressly provides, maybe helpful to just briefly check it out. It expressly provides that the Ombudsman is not bound by any of the three considerations. They are simply considerations.
Well, and they're not exhaustive either.
Correct. And the statutory language of the fair and reasonable test again mirrors the statutory language at section 228 sub 2 of FISMA for the Financial Ombudsman Service.
Are they mandatory considerations?
They are.
Okay.
And the reason they're mandatory considerations is the Ombudsman will take it. Now, my lord, as to how
Is there anything more in the scheme rules? Is there anything more in the scheme rules we need to look at?
on this particular headline point, no.
Because one of the things I was going to ask for help on is that there's reference to level of service. It seems to almost be part of the jargon used in these cases. Is level of service dealt with in the scheme rules at all?
Well, this is perhaps takes us back to a jurisdiction question, so I'll just briefly address it. The answer is that by Rule 2.1, that's page 663, there is a comprehensive list of committed complainants, of whom the first is an individual.
663.
663, my lord.
2.1.
So you'll see A is an individual. Then under the heading "What can they complain about?", which is at 265, you'll see at Rule 2.6, the complaint must relate to an act or omission by someone who was an authorised person at that time. Here, an authorised person includes a law firm such as the Respondent. And 2.8, the complaint must relate to services which the authorised person provided to the complainant. So, neither Parliament's the primary legislation nor in these scheme rules impose a jurisdictional limit whereby a complaint could only be brought if alleging fault or negligence or similar. And that position is reinforced at section 1375 of the Legal Services Act at page 35. So Parliament expressly provided, this is in contrast to financial ombudsman, that the power of the ombudsman to make a direction is not confined to cases where the complainant may have a cause of action against the respondent's negligence.
That was a reaction to a decision of the court, wasn't it?
It was.
Yeah.
They're making clear that the fault components should not be read in.
And once we've got 137, it could be said that any implicit duty to give or common law duty to give reasons is referable to the functions set out in subsection 1. As you said, it's not adversarial, it's inquisitorial. It's not, the focus isn't necessarily on resolving issues between parties, but the duty to give reasons is to enable recipients to see why or how the Ombudsman has applied the fair and reasonableness test.
Well, I wouldn't contradict that at all. So in terms of the fair and reasonable test and what it means, again, I'm not sure there's a dispute on this, but just give you the references so you have them. The Heathermore and Edgecombe judgment of Lord Justice Stanley Burnton, paragraphs 40 and 41 at page 145, which was then affirmed by Lady Justice Appellant in the options case at page 496 of the bundle.
So that's 145.
Sorry, I do apologise, I'm going too quickly. Page 145 of the bundle.
And then 4.
That's Heathermore and Edgecombe.
Yes, I understand.
And then options.
Yeah.
A later case. Lady Justice Appellant, page 496. And the relevant passage is the second part of paragraph 58, B to D in the lettering. So that affirms the Heathermore and Edgecombe analysis. So then associated with this is the Ombudsman's decision-making function when exercising that fair and reasonable jurisdiction, and how she was permitted to consider evidence, the evidence before her. And in paragraph 20 of our skeleton argument, we address that broad discretion to make findings of fact, assess the relative strength of evidence, and again, that is subject to review only on traditional public law grounds. We've relied on the famous passage in ex parte more. Bundle of authorities, page 126. Between D and F. Reference to just not spinning a coin of consulting astrologer, but clearly affording a wide margin to the decision maker on issues of fact. And that's enhanced by the scheme rules at 524. Oh, sorry, that's a 5.24 at page 675. Where an ombudsman is given the discretion from G to make a determination on the basis of what has been supplied and to make adverse inferences in the favour of the right information. So by way of an example, in this case, there was reference made in the course of the complaint by the respondent to having had weekly telephone updates on the costs. The ombudsman held that there was no evidence at all on that point, and properly held therefore that it didn't weigh in the firm's favour in her assessment of the fair and reasonable balance. Then the fourth headline point.
Yeah.
The Ombudsman was not bound to apply legal principles and rules, whether contained in legislation or case law. Rather, she merely had to take such matters into account when determining what was, in her opinion, fair and reasonable in all the circumstances of the complaint.
Could you just repeat that?
Yes, of course.
Exactly how you put it?
The Ombudsman was not bound to apply legal principles and rules, whether contained in legislation or in case law. Rather, she merely had to take such matters into account when determining what was, in her opinion, fair and reasonable in all the circumstances of the complaint. And my Lord, I may take you to two Court of Appeal authorities that make with that proposition.
One of those is options, is it?
Yes, options in paragraph 73, my Lord,
Yeah.
page 501.
Not obliged to follow the common law.
Yes, my Lord, but perhaps the more full account is given in the much earlier case, the Lord Justice Stanley Burnton's judgment in Heathermore and Edgecombe. If we go back to that,
Yeah. So
page
what page?
143 of the Bundle Authority.
Thank you.
So you'll see at the very bottom of the page, just above paragraph 34, the subheading, is the Ombudsman required to apply the law? And the submission of Mr. Spate, the ordinary natural meaning is that he is. That submission is then rejected at paragraphs 36 and 37. I could invite you to read 36 and 37. And when doing so, we just note that Lord Justice Stanley Burnton uses the language, the law apart from section 228 twice, and any rule of law apart from the 2000 Act. So obviously, we're not saying that they can depart, or the legal ombudsman or the financial ombudsman can depart from the statute conferring their powers, or they can depart from other rules. My lords, when you've read those two paragraphs, just briefly note 38 and 39. This is a submission made by Mr. Spate, relying on the Part 6 of the Legal Services Act, the Legal Ombudsman scheme, and saying, well, that contains section 1375, the provision I took you to earlier, and the submission made, anachronistically, is that the later statute must inform how you construe FISMA, and that, of course, is rejected.
Yeah.
And just pausing there, my lord, it's conspicuous, we say, that neither section 1371, establishing the legal ombudsman's fair and reasonable jurisdiction, nor section 2282 of FISMA, establishing the test for the financial ombudsman, nor any relevant case law draws a distinction between legal concepts and common law jurisprudence or legal rules in the way in which the judge below did at paragraph 60 and 61.
What's the distinction between, did you say legal concepts?
Well, perhaps the easiest thing is to turn up the judgment.
Yes, I was going to say, it's easy, just help me just to remind myself how he did that.
Well, if you just turn to and remind yourself, paragraph 60, that is the take into account but not bound by the law, case law. My Lord Justice Coulson referred to the options test at 73, that's referred to in paragraph 60. But then in paragraph 61, the judge below refers to legal concepts. And we say that there is, to the extent that he is trying to draw a distinction between legal concepts and other formulations of legal rules or principles or similar, that just is not borne out as a matter of statutory construction.
Sorry, I don't understand the submission. Not borne out in what sense?
Well, the statute, as analysed by Lord Justice Stanley Burns, paragraphs 36 and 37, does not reserve an obligation requiring the legal ombudsman to apply legal concepts that otherwise gives them a free hand. Instead, they have the free hand.
Isn't he just simply saying, if there's a rule, for example, in legislation, you should take it into account, but you don't have to follow it. But in going through that exercise, you at least have to understand correctly what the rule is.
Well, I may be unfair.
You may be overcomplicating it.
I may be overcomplicating it. I accept that. But I think what he is, and indeed, the first sentence of paragraph 61 finishes when it is choosing to apply those concepts. There, he's talking about application rather than simply taking into account. But
Well, whether you're choosing to apply a legal rule or to depart from it, it's a pretty good idea to understand correctly what the rule is, isn't it?
well, look, I think the answer to that is it is a pretty good idea, but it may not be fatal to the legality of a decision, which is stated expressly to be
In any event,
a fair and
the
reasonable.
question is whether 61 matters to the way he dealt with irrationality later on.
Well, exactly.
It may not.
Well, that's a good point. But I'd just like to, if I may, just understand exactly what 61. So you make a submission in 60. He makes a point back at you, 61, and you accept it. So I was scratching my head at this point when I was trying to work out exactly what you say the right approach it should be,
Yeah.
and where he went wrong.
My Lord,
If that's material. If it's not material, as my Lord said, then don't
well,
worry.
it may be material to our ground 2, because our ground 2 is we don't quite understand what he was doing, whether he thought the legal ombudsman was required to apply the law, or whether he thought that the legal ombudsman was purporting to apply the law and got the law wrong.
Just on your grounds 1, 2 and 3, is it right that if you, at the end of the day, succeed on ground 1, that's enough, even if you don't on 2?
Yeah, my lord, I think we get home
On 1?
on 1. We equally may get home on 3.
That's what that was my reading of it. So in between, sandwiched in between, there is 2, to which this point goes.
To which this point goes.
Which really seems to be more of the same, i.e. 1.
But it
seems to be embedded within 1, not really add anything to it.
Well, that I accept that that is a way of reading grounds. Yes.
So we may be dissecting something we don't need, a part of the anatomy we don't need to bother with. But
Well, my lord, if I can assist you
I'm
with
just,
the
I'd
dissection,
like,
then
I'd like, if you just in 30 seconds, explain why this, what the error was in 61 and why it matters.
my lord, below I took the judge to the case law I just took
Yes.
you to. There is no obligation to apply the law outside the statutory scheme. The question put to me was, well, if the ombudsman is applying the law, do they have to get the law right? To which my response was, if they are attempting to apply the law, they have to. However, if they're not attempting to apply the law, their fair and reasonable jurisdiction confers them a wide margin to reach a decision, provided it is fair and reasonable. And it may be in a particular decision they get the law wrong, but it's immaterial because the decision is in any event fair and reasonable. Hopefully that's a nutshell answer.
There was a nutshell answer. Let's see where it leads us in a moment. I'm not, we'll see.
Yes, my lord. So just before I leave that point, where he said the application of the fair and reasonable test by an ombudsman should not, without more, be taken to imply an attempt to adhere to common law or statutory provision.
So again, the application of the fair and reasonable principle.
Without more should not be taken to imply an attempt on the ombudsman's part to adhere to and apply rules of law of the statute of common law. So when they use the language of fair and reasonable, it's perfectly proper to say that what they're doing is determining something that, in their opinion, is fair and reasonable. You don't have to read in as a presumption, they're also trying to apply the law.
Okay.
The fifth headline point on the law goes to my Lord Holgate's point about reasons, and it's this: consistent with the Ombudsman Service's statutory scheme being one of minimum formality, the level of explanation when departing from legal principles and rules is not formalistic or exacting. The obligation is simply to indicate that the common law principle urged upon the Ombudsman has been considered, but that the fair and reasonable outcome is different for the reasons identified.
Isn't this a classic thing where you know it if you see it on the facts? Like so much public law. I mean, the level of reason surely is going to be a function of the scheme and then the particular circumstances of the complaint.
Well, I think that, of course, is going to be fact-based in every case, but perhaps the way to view it is from the other side, which is to say, is there an obligation in every case to set out the law and then explain why you're departing from it? And the answer is no.
Can I just write down what the submission was again? I got a few words. I want to capture it.
Thank you, Lord.
Do not have to, if you're, sorry.
Well, Lord, if I can pick it up, the obligation is simply to. Is that where you have it?
Just it wasn't very long.
Sorry, I'll run through it. Consistent with the Ombudsman Service's statutory scheme being one of minimum formality,
Consistent with section 137, yeah.
the level of explanation when departing from legal principles and rules is not formalistic or exacting.
Level explanation when departing from legal rules, is not.
Formalistic or exacting. The obligation is simply to indicate that the common law principle urged upon the Ombudsman has been considered, but that the fair and reasonable outcome is different for the reasons identified. So what needs to be justified in the reasons, as it were, is why the outcome is fair and reasonable.
The last few words, but the fair and reasonable
Outcome is
outcome.
different for the reasons identified. Well, if I could just take you now,
Is this relevant to ground 2 again?
it's relevant to ground 1 and ground 2, because ground 1 concerns the run of paragraphs from 72 to 78 in the judgment below, where the judge, as a repeating refrain that something's not explained, that something's not addressed. We say that is applying to exacting standard for reasons. And well, further to your earlier question, what is the reasons obligation? We say the reasons for departing from the law represent a high point of the reasons.
What's the departure from the law here? The legal rule.
Well, I can take you to that very briefly. That was it.
Well, just so I can follow what you're saying. What's the legal rule?
So the
I wonder whether you were talking about incapacity, mental incapacity.
well, that is the number of it.
That's why I wonder whether it was ground 2. Anyway, I'll shut up.
If I may just briefly take to the authorities addressing this point or making good this point. The first is Heather Moore, again, paragraph 49, page 147. Which is invited to read from E through to G. And then that paragraph is picked up in the options judgment at paragraph 77.
Is it saying the same thing?
My lord, it is, but it's refined slightly in options.
Okay.
Because there is an ambiguity, or has historically been argued an ambiguity, as to what is meant by he is free to depart from relevant law, but if he does so, he should say so in his decision and explain why. And what you see in options is that it's fleshed out. And we say fleshed out in the terms that I introduced this headline. That's paragraph 77, 78, page 502 to 503. And then one further reference, which is Charles Street number 2, paragraphs 110 to 112, page 470. And that my language of addressing the submission urged upon them is the language of Mrs. Justin Heather Williams in Charles Street.
So what is it you get extra from the Court of Appeal in options?
It's the paragraph 49 of Heather Moore might have been understood as requiring the law to be set out and then a counterpoint explanation as to why the law wasn't being adhered to or applied. And what 78 says is that's too restrictive and formalistic. And the exercise is not formulaic.
Which passage in Mrs. Justice Heather Williams' judgment?
Paragraphs 110 to 112, page 470, my lord.
Thank you.
If anything, 78 is suggesting if you thought you had to go so far, you don't.
Well, apparently,
It's saying, I don't understand the dictionary in each and every case the Ombudsman was first set out, etc., etc., etc.
model it exactly.
So you don't have to go as far as some people might have thought was implicit.
Exactly.
So it's a slight rowing back.
Exactly.
Yeah,
That-
okay,
that's
right.
exactly why I've taken you to it.
Yeah, okay. And then we go
It
to
softens the obligation
Yeah.
at paragraph 49 of Heather.
so it's 470.
Page 470, paragraphs 110 to 112. The particular sentence of note is final sentence.
The last sentence, the bottom of the page.
Exactly.
That's
That's where I got.
That's
the
how you've
language.
been putting it.
Exactly. We say that's the right way to approach it. Then finally, my lords, the sixth headline point on this: Parliament provided for the Ombudsman to have a broad subjective discretion to make various forms of directions as to redress under section 1372, again subject only to public law grounds of review. This is paragraph 26 of our skeleton argument. And to the extent you need me to turn them up, I can, but otherwise I'll just give you the references. Section 1372 sets out the redress powers of the Ombudsman. It begins with the word "the determination." Definite article takes you back to the fair and reasonable test in 1371. So that's how that carries through. And 1372 permits one or more of 5 directions to be made, which include fee refund, compensatory awards, so on and so forth. And those are capable of being enforced ultimately by way of a court order, should you get there under section 141. So those are, we say, the headline points for the statutory scheme governing legal ombudsman. So maybe briefly then address capacity, which we don't understand the law in relation to capacity to be in dispute to any material degree. For your note, the relevant provisions of the Mental Capacity Act are at pages 19 to 21 of the Bundle of Authorities, section 1.2, page 19, section 3.1, page 20. And my lords, the most authoritative summary of the relevant principles is that of my Lord Justice Baker in Johnston and the Financial Ombudsman Service at paragraphs 36 to 43, which is page 564 of the bundle, with which, amongst others, my Lord Justice Coulson agreed. A quirk of this is that actually that judgment was handed down the Thursday before the hearing below, but as you'll have seen, the judgment was taken into account. It represented a fresh assessment. And my lords, as you'll know, the fact that that case concerned the Financial Ombudsman Service happenstance insofar as my headline points in the statutory scheme are concerned. None of those are affected by the fact that Mr. Johnson proceeded against the Financial Ombudsman Service. Capacity principles don't bear on the statutory scheme. And then, models, to save me turning this up later, I just ask you now to jump into the supplementary bundle.
Leaving the law.
And we'll be coming back to the regulatory provisions, but that is the law, as it were,
Okay.
of capacity.
So can we put the authorities bundle away?
Well, if I just take this one document and then we return to the authorities bundle, that'd be great. it's at page 124. Of the bundle, of the supplementary bundle, tab 26. Dated the 12th of January 2024. These are the submissions received subsequent to the revised provisional decision, but before the final decision. And the reason I'm taking you to these now, my lords, is because, as I said, the obligations on the Ombudsman are to take into account the submissions urged upon them as the law, and then explain why the outcome reached is fair and reasonable. These are the submissions urged upon the Ombudsman by the respondent. You'll see
In response to the provisional decision.
in response to the provisional decision, the revised provisional decision. You'll see, well, the first whole punch, our counsel has prepared this response. And then turning to page 126, sorry, just go back to page 125, just before the bullet points, he challenged your analysis. So these points are submissions knocking the horns with the revised provisional decision. And turning to 126, it's pithy, but it's the law, having been set out by the respondent. So first full bullet point, I have reference to the Mental Capacity Act, Family Procedure Rules.
Sorry, you're on 126.
On 126, my lord. The many clients with mental
Sorry,
health issues.
I'm there, got it.
So you'll see there the statutory provisions are identified, as well as procedural rules. Following bullet point.
Yeah, but Law Society guidelines, they're not law, are they?
They're not, my lord. Well,
It's guidance.
They are, and I'll come to guidance in just a
Yeah.
second. But I just wanted to
Yeah, I just want to be
place
clear.
this before you.
Yeah.
Exactly.
The law's in italics.
Law is in italics. And then, following bullet point, the statutory principle in section 1(2). Which is articulated with reference to the right to litigate. And the following bullet point deals with what was then the leading authority.
Under the burden.
Sorry, exactly. So there you have the statutory provisions, the basic legal position summarised, and case law. Put that away now. I raised that because those were put before the Ombudsman. Then dealing with the regulatory documents relating to capacity, my lords, two are of particular importance. Those are the SRA Code of Conduct and the guidelines of the Law Society. Let's start with the SRA Code of Conduct. Bundle of Authorities, page 687.
Page, sorry.
687. Thank you. Start on page 686. Maybe help just to understand the context of the first paragraph on page 686. It's a principle-based regulatory scheme. And then third paragraph in 687. The Code of Conduct describes the standards of professionalism that we, the SRA, and the public expect from individuals authorised by to provide legal services. If you could then turn again to 688, paragraph 3.1, and read that noting second sentence. So the firm is put on notice of the capacity issue.
Sorry, forgive me, just paragraph number again, I was checking.
3.1 of the Code of Conduct,
Thank you.
page 688.
Yes.
So the due diligence obligation, the obligation to assess capacity, is triggered by reason to suspect.
You did say 3.1.
I did say 3.1, second sentence, my lord. If you have reasons to suspect the instructions do not represent your client's wishes, you do not act unless you have satisfied yourself that they do. So it's the
Well, is that what this is
Yeah, exactly.
addressing? Is this addressing capacity?
I thought there was-
Forgive me, I may be herring up the wrong tree, but
I thought there was another passage in the Code of Conduct more directly in point.
well, my lord, 3.4
Yeah.
is the passage that's picked up in the guidelines. Well, I took you to 3.1 because they all fall within the same.
Well, I put one way perhaps of understanding the second sentence of 3.1 is it's capable of bearing upon capacity, but it isn't limited to.
My lord, that's absolutely right, of course.
But there's nothing specifically on capacity in this section.
Lord, the code does not look horns with capacity.
No, okay.
It's a principle-based
But it's got
scheme,
principles
so-
which are capable of embracing it.
exactly. My
I
lord.
understand.
So it's much like financial regulation. You don't cover the field. You apply a principles-based approach, and those who are required to adhere to the principles have to adjust their conduct accordingly.
yes. I'm not convinced this relates to capacity at all myself.
Well, my lord,
I read that as where the second sentence is following off from the first. Instructions from the client or someone properly authorised to provide instructions on their behalf if you've reason to suspect the instructions do not represent your client's wishes. I think the law's right that the language is capable of covering capacity.
well, I don't think I need to
Moment,
go
I'm
further
not-
than that.
All
The
right,
context seems to be pointing in a different direction.
that's what I thought.
Well, I don't think I need to go further than
Doesn't
say
matter,
it's
does
capable.
Isn't 3.4 enough?
3.4, my lord.
Why do
yes.
we have to go around the houses?
Well, you've obviously read 3.4, so I'll then take you to the Law Society guidelines.
Yeah, it's interesting that it's not been covered, isn't it?
Yeah.
So, my lords, the Law Society guidance begins at page 701, the same bundle. And it's just that, it's guidance. It's to assist solicitors to meet their duties under, you see it's from 702.
Does it have any disciplinary implications though if someone doesn't follow the guidance?
Well, I would have to come back to it.
Okay.
But you'll see at 702, regulatory and legislative obligations. Third paragraph of that, this guidance will help you to recognise and meet your duties under the Mental Capacity Act. So it's designed to assist the discharge of obligations under that act.
Yeah, but before you get there, you've got at the bottom of 701 types of vulnerability. And vulnerability is a concept used by the Ombudsman in her decision.
It is, my lord. And if we look at the three examples of vulnerable clients, you'll see the first are clients who have capacity but are vulnerable. The second is clients who lack mental capacity. And the third are clients who are vulnerable to undue influence.
Well, the first category is clients who have capacity to make decisions but need extra support
Yes, my lord.
because of mental and or physical disabilities.
Yes, my lord.
Because I didn't read the Ombudsman's decision letter as confined to mental incapacity or litigation capacity in the strict sense.
Yes, my lord.
If you read it as a whole.
The criticism made of the firm is that they don't provide support and they don't conduct an adequate capacity assessment. Well, you're right. So, and what you'll see, moving on then to the third paragraph. Sorry, I apologise. We now go to page 702, final paragraph. There, the SRA code is picked up at paragraph 3.4.
Well, before you get there, if you, from the previous paragraph, you fail to meet the needs of a vulnerable client, then
The
third bullet,
Yes, ma'am.
sorry, then you're on to the last paragraph, 3.4. So thank
Yes,
you.
ma'am.
Sorry.
You're right. There is the link to the legal ombudsman is made. So paragraph 3.4 of the SRA code, in the final paragraph of that page, provides context for solicitors making sure you have the skills and processes to be able to identify a situation where someone may have reduced capacity and how you approach the situation. And then at 703, vulnerability indicators. Risk factors that indicate a client may be vulnerable include, and you'll have from our skeleton argument, that a large number of those were present, found to be present by the Ombudsman.
So which ones are you relying on?
So you may not be able to number the bullet points for you, but maybe 6 on mental health problems.
Yep.
And 4 lower ADHD, attention deficit hyperactivity disorder. Then a further 2 down, psychological or emotional factors such as stress. And then if we jump down a bit further, long-term alcohol or drug abuse, exposure to financial abuse. And we say that it's clear from the guidance that those vulnerability indicators are not conflated with a lack of capacity. The presence of such an indicator is not treated as equating to a lack of capacity. The final sentence in that page does not follow that because a person has a risk factor, they are vulnerable, but you should be alert. And then, going on to 7.4, the third paragraph, one or more of these risk factors may mean, and miss out that subclause, and we'll come back to shortly, that they may lack capacity to make relevant decisions and to give instructions.
And to understand relevant advice.
Yes. So you'll see the twice may indicates that vulnerability indicators are not the same as a lack of capacity. But when put on notice of them, that may be the trigger for chasing up whether or not the client does lack capacity, the due diligence obligation. And then, my lords, if you jump through to 709, there is a section, clients who may lack mental capacity and may repeat it. And again, the SRA code is referred to. It says, as such, you must satisfy yourself about their capacity if you have any doubts about whether your client has capacity to give instructions. So that is an obligation that is triggered at a low level. Any doubts?
There's the following paragraph as well.
Yes, Lord. My lords, you'll be live to Kathleen Johnson. There was a capacity assessment which, had it been upheld by your lordships, would have unpicked 12 years worth of litigation. So that paragraph that my Lord Justice Holgate refers to is a very real risk.
Yes. I recall.
Do we need to know anything about the last paragraph on 709? There's been reference to that in the papers.
Separate guidance.
Mm.
Yeah, my lord.
It said, I think, by the judge that the Ombudsman didn't take that into account.
So my lord.
That's not a criticism in the judgment. It seems to be a comment in passing.
And it can only be a comment in passing because, of course, this is guidance. The mandatory obligation under 5.37 of the scheme rules relates to rules.
So the answer to my question is no, we don't need to know.
No, don't need to worry about it. And my lords, in fact, I can go further. If you turn to page 717, you'll see a list of resources and practice notes and so on. It cannot be that an ombudsman who is obliged to act quickly and with minimum formality has to interrogate all hyperlinks in a document in order to discharge their functions. They would never make a decision. So yes, I think we can move on.
Although that hyperlink does seem to be quite relevant, doesn't it?
It does all, but as I say, the key point, our key point is, it is not within the scope of the mandatory consideration.
It's going to mental capacity as opposed to the broader concept of vulnerability.
My lord, as well.
Was it actually prayed in aid by anyone in the submissions they made to the Ombudsman?
Well, it wasn't.
Right.
Well,
This is
I've taken you to the
this is judicial review.
Yes, exactly.
Right, okay, yes.
Classic example of what I said earlier.
Yeah, my lord, and that's why I took you a moment ago to the passages which set out what the submission of the firm was
Yes.
on the law. So I didn't have to.
This wasn't raised by anybody at any point,
My lord, I don't
so
believe so.
we should not be worrying about it.
Precisely.
Yeah.
So that's the law. Moving on then to the factual background relevant to ground 1 to 3. 3 introductory points, my lords. First, a High Court, we do have some sympathy for this, got, we say, considerably confused as to what was and what was not before the Ombudsman prior to her making the decision, and so what was relevant to the claim, because my lord, the Holgate says, this is judicial review, what's before the Ombudsman is the key consideration for relevance. My lords, if I could just invite you in the judgment to read paragraphs 38 and 45(1), that'd be great. 45 Roman 1.
So this is a paragraph identifying some of the submissions which were rejected, some of the submissions made by the respondent to this appeal, which were rejected.
Yes, my lord. And they rejected on the basis that the document.
So these were things that you won on.
Yes, my lord.
So how are they relevant to the appeal?
Because I just said a moment ago that the judge below, I'm afraid, got confused as to what was
It's
before.
not a state trial.
Yes, my lord.
I mean, the judge is not on trial.
My lord, I agree. Perhaps I could.
What? There's some document here that wasn't before the judge. Sorry, wasn't before the ombudsman.
My lord, exactly so.
Which is which?
Well, in that paragraph, he is referring to a number of witness statements.
Yeah, but do they bear upon the grounds of appeal?
My lord, the reason I raised them as this introduction point to the facts is because the judge, and I'll take you to passages, despite having found that documents of this nature, which weren't under the Ombudsman's nose but irrelevant, nevertheless refers to and relies on them in his judgment.
Okay.
That's why we're here.
Whether or not they fall within what's described in 38.
But the reason I've
They
taken
were
you
just
to
simply documents which weren't before the Ombudsman.
my lord, and at 45(1) last sentence, he clearly intended not to rely on these.
Yeah, well, whether he's written these paragraphs or not, the principle is one
Principle
of
is the
law which
principle.
we all are familiar with.
Exactly, my lord. So if I could just take you to the examples of this, so you have them, and so that the risk is not repeated, as it were, in this court. The first is paragraph 5 of the judgment, where there is reference to and quotation from an attendance note of a meeting with counsel Mr. Martin Kingerley on the 9th of September 2020. You'll see that towards the
Paragraph
end,
5, you say.
paragraph 5 of the judgment.
Yeah.
And there's quotation, quite extensive quotation from that in the final sentence. But that document was not placed before the Ombudsman during the course of the complaint. And for your purposes, my lord, it's now found in a supplemental bundle. I don't ask you to turn it up, I'll ask you to note where in the supplemental bundle it features.
Is this the further supplemental bundle?
And this is the original,
The heavy one.
the heavy one.
Right, okay.
It features in section E, which is entitled Documents which were referred to in the judgment but were not before the Ombudsman. And it's tab 35 of that, page 279.
Right.
And he falls, I'm afraid, into the same error, paragraph 11.
Hang on a minute. So, in the factual background, he identifies a part of the factual background, and there's a document there referred to which was not before the Ombudsman,
Yes.
and that was relevant to his decision at where?
At paragraph 77, final sentence. That refers to the
77.
So it's only one. It's only one sentence. It's the final subclause. He criticised the decision for not explaining.
So it's the last few words, to have checked her own view with that of leading counsel.
Exactly.
So the only thing that could be referring to is what we see in 5 last sentence.
Well, that appears to be the logic of the judgment.
It may be that that was based on something else that was checked with leading counsel, albeit not on that occasion, and was before the Ombudsman.
Well, my lord, this is the reference to leading counsel in the judgment,
Well, yeah.
and that's what picked up. So, I mean, yes, I raise this, as I say, all under the main point that there's a red flag here, which is that the judgment contains reference to documents that were there, and they appear to be.
It only matters if it's relevant to the decisions that he made.
Exactly, my lord. Exactly. I should say, I don't think this is relevant to the decision, but paragraph 11, exactly the same issue arises. My lord,
Which bit in 11 wasn't
it's the
before?
reference, it's the quoted passages in
It's
the
the
attendance
size
note.
bit, is it?
So this is the attendance note of a meeting with George Harley, counsel, which again features at tab 36 of the supplementary bundle. It wasn't before the Ombudsman. And just, I'll also have it, the respondent's go to an argument, paragraph 22, refers back to the first of those two examples I took you to. So unfortunately, it's crept into my learned friends go to argument, the same issue.
Let's go to 22, you said.
Paragraph 22 refers to the consultation with Martin Kingerley, which wasn't before the Ombudsman. The second overarching point I make on the fact is that the Ombudsman's findings of fact must stand, save where those were held to be irrational by the judge below. My Lord Justice Coulson has reminded that this is not an appeal in the sense of revisiting the facts, and that's quite right. The reason I raise this again is because I'm afraid my learned friend Stoic in paragraph 22 and the unnumbered paragraph that follows, the respondent seeks to go behind findings of fact, essentially opening out issues again that were resolved by the Ombudsman and were not found to be irrational by the trial judge.
Are those the issues to do with the handling of costs?
Now, my lord, those are the issues as to how the capacity certificate of Dr. Isaacs should be construed.
Which he dealt with in 79.
She dealt in 79 in
Second part of 79.
My lord, exactly. He says that it's not
Oh,
only
sorry, the first part of 79.
And the final point is that the court must also be live to a separate but related risk, which is that submissions of the respondent which contradict the ones they made during the course of the complaint you get no mileage before the court. This is a working out of my earlier point. Paragraphs 11 and 26 of my loan defence argument refer to a report by Dr. Isaacs as not going as far as saying that CXV lacks capacity. But the judgment below, paragraph 14, final sentence, and 55, Roman 2, record that a directly contrary submission was taken by the respondent before the Ombudsman.
To the effect that
The effect that it did get capacity. It was a finding of incapacity. Those are the headline points.
But the judge found that the Isaac certificate should be read as it said.
Well, exactly.
So where does this point go?
I've just, my lord, identifying the issue in case this court is led into error by thinking that that factual issue remains different or live somehow. I will move straight on.
Yes.
The contemporaneous documents. I don't want to get bogged down in this, my lord, but the reason I raise it is because the decision, both the revised provisional decision and the final decision, are introduced, and for your note is a page 217 and 236 of the core bundle, by a statement that the Ombudsman has read and reviewed all the evidence that's been provided and considered all the comments.
did you say core bundle?
Core bundle. 217. The 217, I have read and reviewed all and considered all. And then you have equivalent wording 236. And the reason I raise this, my lord, is because the Ombudsman's decision is rightly and properly concise in its analysis of some of the issues. The judge below took issue with its concision and held on multiple occasions more by way of explanation was required. And what I'm hoping to do now briefly is establish that the matters that the judge below was concerned with were properly before the Ombudsman, and that the reasons that she gives therefore must be understood in the context of having grappled with these points, but just not put them in express terms in the decision. And I say that the contemporaneous documents demonstrate three things. The presence of the indicators, as we refer to them, at the outset of the instruction of the respondent and thereafter. Secondly, that the indicators gave rise, or rationally can be found, ought to have given rise to doubts as to the interested party's capacity. And third, that the interested party in fact lacked capacity in the relevant period. Because at this point, we'll need a supplementary bundle.
Well, that last point has been dealt with by the judge at 79 first
Exactly.
name.
So that's done.
But the real question is, how do things seem to the solicitors?
Well, exactly. So the first two of those
The first
three.
2 points.
Yes, my lord.
But also the other point is, as I understand the reasoning, it's not limited to incapacity.
Exactly.
It's expressed it more broadly.
Well, exactly.
Yeah, okay. I just want to make sure I'm not misunderstanding.
No, my lord. Just a,
So we're looking at these from scratch, are we?
no, well, I'm going to take you to a few points with reference to the judgment on the side, so you understand what the judge hasn't drawn attention to, which we say bears on the issues.
Right, so we have to have the judgment open.
Judgment in one hand. I invite you please to read paragraph 76.
76.
Yes, my lord. Where he says that there is no evidence that the defendant had regard to or grappled with certain considerations.
Yeah.
And what I'm hoping to do is establish that the Ombudsman did have regard to these. And moreover, they are present from the very first documents in the chronological chain.
Yeah. So we're going now to the
So
supplementary.
now going to the supplementary bundle
With this open, yeah.
with this open. And the third document we want is behind tab 2, page 7. This document is accepted by all parties, I think, although dated the 16th of September had been misdated.
It was the 8th.
It was the 8th.
Yeah.
There's a bit of a perennial problem with misdating, so I'll show you in a moment. But this is the 8th. And at paragraph 76, the first criticism made is there's no evidence that the defendant had regard to the fact that the IP had consulted claimant on an urgent basis. And if we look at paragraph 1,
What's an urgent meeting?
what's an urgent meeting? And my lord, if you turn then to
But is the criticism that she doesn't say in her decision letter it's an urgent consultation?
well, I think that, well, there are two issues. The first is that the criticism made is that there's no evidence the defendant had regard to.
But yeah, but how do you, this is the point, how do you provide evidence you've had regard to it? Does that mean you've got to refer to it explicitly? I thought the law was absolutely clear on this. You don't have to.
Well, exactly.
The real question, according to oodles of case law, is whether there's some positive indication that you disregarded it.
Well, exactly. And moreover, here we have an express statement that all the evidence and all submissions were considered. So you must proceed.
Because but just simply by taking us to that document, that was before her, are you relying upon the general expression, I've read all the material?
Yes, my lord.
Yeah, okay, I've got the point.
Well, but the point which I'm trying to meet is if you were to step back, the decision below, the judgment below, is a rationality finding, or an irrationality finding, as it is, in the context of a pleaded claim that did not include a reasons challenge. So the reason I'm taking you to this is because the judge below has referred to the absence of evidence as somehow demonstrating irrationality.
Yep.
It's not about the inadequacy of the reasons.
No, get that.
And so what I'm showing is that
So
the contemporaneous record.
so the attendance note that you've taken us to, you say that ticks 1.
Yes. And then, my lords, if I could just invite you to read paragraphs 2, 4, 8, the key paragraph
Of this document,
of this document,
248.
2, 4, and 8.
Yeah.
And then at the top of page 9, underneath the heading cost, the first sentence. And you'll see, having read paragraph 76, that there is criticism of the decision for not having grappled with the fact that clients can present as emotionally raw
Yeah.
in distress. It's there. We also say the paragraphs I took you to just a moment ago, key paragraph, paragraph 8, those are where the indicators, vulnerability indicators, are present in the first consultation. The judgment at paragraph 5 deals this one in contrary with the document that wasn't for the Ombudsman, so I can leave that out. So then we get to paragraph 6 of the judgment, which refers to an attendance note dated the 14th of September. That is in the bundle. At
Hang on, I
paragraph
thought
10.
we were looking at paragraph 76 of the judgment.
Yes, my lord. So just to give you context for the next document I'm going to take you to, this is, the judge deals with this at paragraph 6, but I'm staying with 76.
So he refers to a document in paragraph 6. Is that an attendance note?
That is, and the attendance note is found at page 10.
Correctly dated?
This one is, but my lord, there is a problem because page 5 of the bundle is identical and it's dated the 7th of September. So the respondent has produced two identical documents a week apart. I think everyone's proceeding basis.
So we go to find the one of the 16th September, we go to
Sorry, supplementary bundle, page 5. Top left corner, 7th September 2020. And then we turn to supplementary bundle, page 10, top left corner, 14th September 2020. It's the same document. And everyone in this case so far has treated this as being dated the 14th because the first instruction was on the 8th. But putting it briefly, in the first 3 tabs of the supplementary bundle, we have 2 misdated documents.
well, it's a software function, isn't it?
Yes, my lord, but the version I'm taking to is the one at 10.
How does that differ at all?
And 11 is the same as well, is it?
Let me say.
But if I've understood the software function correctly, there might have been material added to what was created on the 7th September, and that will be picked up on the 14th September.
I think that's how it works, but actually, that obviously only works
Does this
going
matter?
forwards. It doesn't matter, my lord.
Oh, good.
Well,
The same. They're both at 6
I think they're identical. The reason I'm taking to this document at 10 and 11 is, again, urgency of instructions at the very outset. No, it's called out of hours to take urgent instructions. And then going down to the second bullet point, statements, nobody believes our allegations.
I'm sorry to be really dense and slow, but the one at 10 and 11 is dated the
14th.
14th. Okay, that's the one the judge had in mind at paragraph 6. Okay.
Exactly.
Yeah.
And
where are the bullet points on 10? Which are the bullet points?
hole punch.
Hole punch.
The second hole punch, by the way.
Right.
Child arrangements.
Yeah.
And then if we go down, Sean's best person report, nobody agrees to allegations. The next paragraph, we cannot force the authorities to believe her. Risk that the authorities do not believe her allegations, she pursues them, court will decide, so on and so forth. There's an allegation of poisoning of a child, no evidence in support at all. And then there's reference to seeing a psychiatrist since February, reference to drinking too much, better now that she's not drinking too much. And then next page, over the page, Mr. CXV, second subclause, claims her ADHD medication is causing psychosis. These are the indicators.
So you say those 2 documents on their own make plain that each of the 4 sub-paragraphs at 76 are wrong.
Lord, exactly.
Understand that?
And what they go to show, going back to 75 now, 75, the judge below takes 3 particular facts in isolation, assesses them each separately, and finds that they don't make good what he regards the finding in the decision to have been, which is that mental health issues equate to a lack of capacity. And what those documents show is that those 3 findings are amongst a multitude of findings, all of which are vulnerability indicators, all of which are known at the same time, and all of which, we say, give rise to the relevant risk to trigger the due diligence obligation. And also, I don't think I need to then take you to the psychiatrist's letters on the 9th and 13th of October.
Before you go, can I just take you back to 75 briefly?
Okay.
What leads to those 3 points in 75 arguably is the assertion that the defendant in her decision placed reliance on these 3 particular facts.
Yes, well, she did.
Can we see where she did that?
Of course,
Because it has to be read in context.
it does. Manuel. So this is in the revised provisional decision, core bundle. The revised provisional decision begins on page 219.
Where does she identify these three?
And she identifies those three facts on page 222.
Starting at
So if you just go back, sorry, I apologise for this. If you go back to 221, having set out the Law Society guidelines that I took you to, and at 1.2, noting that indicators should have alerted the firm to the fact their client was vulnerable or lacked mental capacity, which she clearly has in mind that vulnerability indicators are not the same as a finding of lack of capacity. At 1.3, she says, I've considered the evidence and have summarised where I feel it was clear that CXB should have been considered vulnerable and where there are indications of issues of mental health. And that is where we get to 1.3.1 and 1.3.2 and 0.3. The judge never considers 1.3.4.
the 3 points you can find in the first sentence of 131, can't you?
Well, yes.
And they're picked up in 132 with the reference to she thinks she's being drugged as well.
Yes. And then what you have at 1.3.4 is one of a number of examples of the firm having appreciated that she may have lacked capacity in the past. This is a contemporaneous record of the firm appreciating this, but no capacity
Well,
assessment is conducted.
That's a separate point, isn't
It is a separate
Can we-
point.
Can we come back to that? Your complaint really here is that the ombudsman takes into account the totality of the evidence, you say, to reach the conclusion that she does, highlights a number of incidents as part of the general picture, number of factors as part of the general picture, and the judge takes each of those separately and says by themselves, each by itself does not amount to evidence of capacity or liability, and ignores the totality imperative.
Well, you have the point. And it brings to mind the famous passage in your Brown Wilkinson's judgment in The Edge about the air raid wardens during the Second World War. If each one sees a plane coming, that might not be of itself enough to give rise to a sensible risk assessment. But taking totality, it looks like there is a bombing campaign that's commenced. It's the same idea. You can't isolate each of these and criticise it as not being dispositive of a point for which the Ombudsman has relied on many factors.
Isn't there a more basic point here that these are all references to effectively the contemporaneous documents right at the outset?
Exactly.
So it wasn't as if, I mean, this isn't looking at everything in the round. This is identifying things from the outset of the relationship. Hence the reference to those two early attendance notes.
Well, that's exactly why the Ombudsman has placed weight on them.
Yes.
But what the judge below does is take the vulnerability indicators referred to in those very early documents separately.
Yeah.
And what we're saying is that they shouldn't have been taken in isolation. That's an error. And it's contrary to the approach one ought to take to reading Ombudsman's decisions, particularly where they are introduced as being a summary.
If you go back to what the judge said at 75, in the first sentence, he says the judge placed reliance on these 3 particular matters to justify the view that more should have been done to assess capacity. Actually, not simply saying more should have been done. And then when you look at the reasoning he gives on each of Roman 1, 2 and 3, he's saying that each matter does not of itself indicate incapacity. And I was wondering if you go back to what Ombudsman said, for example, the 131 and following, did she actually suggest that was so? Do you see that in 131?
Well, my lord,
132 signals that consideration needs to be given and an assessment made to establish if, for example.
yes, my lord. So I think that we would read it the same way that you've indicated. And it may be helpful just for me to quickly address the revised provisional decision now, since we're with it. So just to go back, if we may, to 219. There's reference there expressly to the fair and reasonable test. That is what the Ombudsman is applying. In this appeal, we are principally concerned with the first section of this revised provisional decision. But you'll see at 220 there are 5 grounds of complaint. The first of which is the firm failed to adequately assess litigation capacity. The second is the firm had charged excessive cost for work completed. I've taken you to 1.1 to 1.3. 1.4 to 1.6 address the submission made by the firm that there was no proof the client was mentally ill. So that is a bold submission, given what you've just seen in the contemporaneous record, and she dismisses it. 1.4 to 1.6. At 1.7 to 1.9, she then addresses mental health issues or lack of capacity. You'll see 1.7, mental health issue or the CXV lack capacity. That language is then repeated in 1.8, mentally unwell or lack litigation capacity. And 1.9 is a key paragraph here, because the Ombudsman refers not only to mental health issues, but also to erratic behaviour and paranoid and delusional behaviour. And you'll see in the final sentence of that page, 223, going on to 224, she makes a finding that was properly open to her, hasn't been challenged in the proceedings, that a document stating on the 18th of October that there was an assessment of incapacity by the firm on some days and that it was growing, properly construed, indicated that there were indications of a mental health issues and capacity prior to that date. And that's all part of her broad fact-finding discretion.
Is it right to talk about fact finding?
Well, Lord, in what sense?
The Ombudsman has a duty to come up with a fair and reasonable response. It's no more and it's got to be quick, and it's not, and it mustn't be formalistic. Is it appropriate, therefore, to talk about fact finding?
Well, my Lord, she has to work out the factual basis upon which she's going to assess fair and reasonableness.
Yes, but is it fact finding as you would expect to see in a more formal decision, like a judgment, for example, the Emery and Reinhold standard, where you have to resolve the main issues and so on, which is appropriate to an adversarial?
Well, I follow now the thrust of the question. So she has to line up some facts which lead her to the decision. What she doesn't have to do is lock horns with the factual picture as a court would, and there is abundance of case law to the effect that that is reflected in the fact that the evidential rules are different, there's no obligation for an oral hearing, so on and so forth. It's a more impressionistic.
I mean,
fact
interestingly enough, when you were taking us through the cases on reasons in the Ombudsman context, I think it was option where it might have been in your case, but it was saying that the reasons should enable, I paraphrase, the court to see that the decision isn't tainted by irrationality.
Yes, Mark.
And all paragraph 1.9 is doing is identifying a comment made by the respondent to the appeal, which the Ombudsman says, well, if you read that, that seems to demonstrate that there were problems before the 18th of October because it says by it had become apparent. Erratic, some days paranoid and delusional.
Lord, yes.
So
that is all of a piece with those very early documents having triggered, or what was known at a very early stage of instruction, having triggered an obligation for us to take an assessment.
yeah.
And it being a summary is one of a number of similar examples. I won't take you to the others, but they are there, unless you give assistance to the court. So then 1.10 to 1.11 address the mental health issues which are, in a later capacity report, identified as the cause of the lack of capacity. The delusional system, paranoid psychosis. A bit more about that at 1.12, 1.13, but then picking that up at 1.14 to 1.18.
Yes.
This is, we say, the key analysis, and the judge below doesn't refer at all to 1.15 to 1.18 at all.
So it doesn't refer to,
So 1.15 to 1.18.
opposed to 114.
It does refer to 1.14, and it doesn't go on to consider the rest.
Can I ask about 114? Are you making submissions at 114?
I am about to.
Okay, fine.
So at 1.14, the Ombudsman finds indicators present at the outset put the respondent on notice of the need to assess capacity. And she emphasised not simply mental health issues, such as paranoid psychosis, but also the respondent's assessment of their client was deeply disturbed and erratic. And the deep disturbance and erratic conduct inform the reference to mental health because there is a client who is manifesting as potentially lacking capacity and is vulnerable. Well, if I was intending to move now to 150.
Well, I don't want to take up time, but what seems to be 114 is quite a crucial paragraph.
I'd agree. I'm certainly in criticising the judge for stopping at 114. I'm not saying 114 isn't important. I'm saying that the ones that.
Where does he deal with 114?
My lord,
Seems to be in 74. Page 69 of the court bundle.
he deals with first at paragraph 27, Roman 12, page 58 of the court bundle.
27.
Sorry, Mr. Cosman, give me that reference again.
27, Roman 12, page 58 of the bundle. And I believe, my lord, you have the correct reference, paragraph 74, top of page 69. Where he relies on 1.14 as evidencing a conflation of mental health conditions and a lack of capacity.
Yes.
Which is, we say,
Sorry, where's that?
but this is
The beginning of 74, yeah.
yes. So the core vice, as he sees it with the decision, is that there is a conflation of mental health issues with lack of capacity.
Yeah.
But we say, and I'm taking you to most relevant paragraph, that is a vice.
Well, it does go back to 114, it seems to me. And 2 points, if I may. First of all, line 6 or 5 of 116 of 114, the sentence beginning, having.
Yes, my lord.
Having to do all this provide, I have concerns that the firm were aware that CXV had mental health issues from the first meeting on 9th of September, and that they should have taken steps earlier on in the process to assess litigation capacity. And perhaps the judge is reading the word therefore after and, where you say that's not right. In other words, that it was purely, your case, it's not purely on the basis of mental health issues that the Ombudsman has reached the conclusion in the second part of that sentence.
Well, you're right. There is a therefore read in, and there is no regard had to the sentence that follows that, referring to the client being deeply disturbed and erratic behaviour.
What might a point that could be taken against you, I'm not saying it's right, could be, is that in the previous sentence, there's only a reference to the mental health issues. So that might support the argument against you.
My lord, and here we reach the point as to how these decisions are to be read.
Yeah.
This is not a statute.
Okay.
It falls to be read in the round, and we say 114 read in the round demonstrates that therefore shouldn't be there.
Can I come to the question I was going to ask, which is a bit later on? Where is the correspondence that's referred to in a few lines further down? The firm in their correspondence with the Ombudsman, highlighted at point 17, state that their client was deeply disturbed and was erratic.
Yes, my lord.
What is that correspondence?
So that, I think, is actually a typo. It should be 1.9. Because that is where the reference is to growing erratic.
And where do we see that?
And those are the comments on the provisional decision.
Yes. Apologies, my lord, I missed that question.
Those are the comments on the provisional decision. The firm's comments on the provisional decision,
Well,
1.9.
It would be the first provisional decision.
Yes, my lord. If I may
This
just
is a revised
Yeah.
provision.
All right. I mean,
That's what I assumed it was, but
well,
but it should
My
be,
lord, I have the bundle reference, if that helps.
yes, but we should change point 1.7 to 1.9.
I think that's right.
erratic is there. I can't see deeply disturbed.
Well, can I just give you some references then, which
This is to the presumably the original documents.
the original document,
Yeah.
which I think should
SB.
make this good. SB, the 23rd of October 2023 letter, which sets out, sorry, page 115. my lord. This is the 23rd of October 2023 letter in the course of the complaint. And the passage that's been referred to is page 117, final full paragraph.
Yes, the quotation in paragraph 109 is at the last, it's 4 lines at the bottom of 117.
Yes, my lord, exactly.
Where is does the phrase deeply disturbed appear in this document? Or is that a paraphrase?
No, my lord, it does in terms. I'm just going to try and find it for you. Apologise if it's easy to hand.
We'll come back to that.
Yes, my lord, it may be that I need to come back to you on that. I don't have it. I can finish it right now.
Right.
So I was just at 114, 1.14, 1.15 is the
Yeah,
revised.
before you leave 114, we looked at the sentence which referred to possible need to assess litigation capacity. But the sentence reads on, and to make sure that she was It refers to support. Fully supported to make decisions, etc., and then the text which then follows, after the reference to 1.9, the firm did provide support to CXV, but at significant cost to her, which links into section 2 of this decision. And at the outset, the firm should have considered other, and then it's reference to, and that's all discussed in the correspondence, and I appreciate that the firm disputed this point, but there is something which goes beyond mental incapacity.
I agree. And of course, ultimately, the litigation can be appointed on the 20th of November. For the
When there
hearing.
was incapacity, yeah.
Yeah.
So this is talking about support.
It is. And that's what paragraph 1.50 deals with, my lord. And then you'll see final sentence, the reference to a cause for concern. And that cause for concern has to be read with what's come before in the decision. So these are vulnerability indicators, capacity, and so on, need for support. (160) has both issues with mental health and then over the page, erratic demands and interactions. But again, it's not just mental health. The judge below is wrong to see it only mental health. And then 1.17 to 1.18 is a rejection of the Respondent submission. Well, I think I may have the reference. Sorry, false alarm.
Well, the opposite of false reassurance. The key part of your case is that the Ombudsman was entitled to come to the view she expressed in the last part of 117.
My lord, exactly.
That's it, isn't it?
It is, my lord, but it's not quite it, because the other feature of this case is that there's a final decision which goes a bit further on this, and that gets, with respect to Judge Lowe, fleeting reference, paragraph 32, but it does merit your attention to take you to it. It begins at page 240 of the bundle, where again the fair and reasonable test is set out.
Sorry, page number again? Sorry.
240, fair and reasonable test. 241, final decision, see by the second hole punch, there's an adoption of the revised provisional decision, final sentence of that paragraph, where a comment has not been specifically referred to as not hasn't been considered. And then over the page, you'll see the second hole punch goes back to the revised provisional decision at point 1.3 in the final sentence. And in summary, it highlights the examples of information provided by CXV at the outset, which should have raised cause for concern about the capacity to act. And then if I could ask you please to read open the next page on 243, the paragraph beginning the firm, and note
They all start.
They all start.
the first full paragraph. But the key point here is that in the final sentence, the language of any doubt about capacity mirrors the Law Society guidance language. So that's
This is which paragraph?
this is by the first hole punch, first full paragraph. Firm states that my revised provisional decision does not state. So
I'm just looking for the Law Society.
I don't think it's expressly referred to. I think what you're saying is that the words.
well, if you go back to 242, the quotation between the hole punches, second paragraph, You must satisfy yourself about their capacity if you have any doubts about whether the client has capacity for instructions.
Yeah.
And then she uses that very language
Yeah.
on the next page.
And again, there's reference to support from another family member.
Exactly. Yes, my lord, deeply disturbed client, I have the reference for you. Page 81, supplementary bundle.
Yes.
First sentence of the first full paragraph. From education started by my personal daily work and support for deeply disturbed client. That's the submission date of the 7th of February 2022.
This was a front-loaded case from the start, requiring my personal daily work and support for a deeply disturbed client.
So I'm just catching up with you. That's which paragraph?
Page 81.
Yeah.
9-6.
Ah, yes. Thank you.
And so then just finishing up with the final decision, back on page 243. Second hole punch. The Ombudsman refers to the submission I took to you earlier about the law, legal provisions, and locks horns with section 1.2, the Capacity Act, and the case law, which was referred to. And then the final paragraph, and my Lord Justice Holgate, this may respond to the question you asked me at the very start about what does ground 2 go to. Insofar as the firm is correctly articulating the law, the Ombudsman states in terms, I do not agree with the comments being made by the firm, and then sets out what she regards as fair and reasonable, that she'd expect to see that the solicitor would show they had established capacity due to the issues they'd be made aware of in the initial instruction. We didn't see evidence that was the case. We say, to the extent she is departing from the law, because the law was set out in the paragraph above, that explains and discharges her reasonable application as to what's fair and reasonable in her opinion. And then the final paragraph, just to draw your attention to here, on the next page, 244, first full paragraph, the firm has given a view that my analysis of CXV's ability to give instructions to the firm so that she always lacked litigation capacity to the continuing history of poor health. And the Ombudsman goes on to explain that paragraph and the one that's following, that that's a mischaracterisation of the point. And of course, that is what the judge below does as well. So, my lords, I think I've addressed you on paragraph 74 of the judgment and how the indications of mental health condition and indications of lack of capacity were not in fact conflated. The decision is read properly in the round benevolently.
Yeah.
And that the statement at the end of paragraph 74, about, in my judgment, the defendant needed to address and explain at a minimum, is a criticism of the Ombudsman for not explaining a decision or a conclusion she didn't make. And as a result, that can't be right. In paragraph 75.
Sorry, can you just explain that? In other words, you didn't conflate the two.
Exactly.
Therefore, I see.
So it's unsurprising there's no
You don't
explanation.
actually give reasons for something you're not saying.
Exactly, my lord. Yes, that's a pithy way of catching the point. Paragraph 75, you have my points about this being cherry picking and an error of approach, as well as overlooking the conclusion or the consideration at 1.2.4 that the firm itself had begun to recognise issues. And at 1.9, the Ombudsman assesses that those were present from the outset. And just for your note, the very final sentence of 75 Roman 3 states it was not reasonable in this context for the defendant to rely on the notion that the suggestion was located for the 8th of September 2020 meeting, as though that suggestion was coming from a medical professional or arose from the conduct of the interested party herself at the meeting. But you'll have seen that that record makes clear that it is the husband that's advancing that. So the suggestion that it was coming from a medical professional just simply isn't borne out. When reading the decision correctly and benevolently, indeed it's stated in terms at 1.3.1, her husband suspected that it was causing psychosis. So it's just a criticism of the decision, but just can't be reconciled with the face of the.
Sorry, the reference to suggestion in inverted commas
Yes, my lord.
is from where? Is that from the decision?
I think it may be at 1.3.2 of the revised version of the decision. The tenant's note clearly states that drugs have been taken and that there is a suggestion of psychosis.
Right, thank you.
But that's immediately underneath the quotation from the original tenant's note, which says her husband suspects it was causing psychosis.
The way I read that was that the judge was saying not that the Ombudsman had failed to record the fact that it came from the husband, but rather that she failed to assess the significance of the fact that it came from the husband in what was a highly contested and emotional family law dispute.
Well, again, you have my point that that is to take this factor in isolation and ignore all the many other indicators. Of course, there is the curiosity of this case that the husband turns out to be right, according to medical experts, and that it is the amphetamines for treating the psychosis that cause lack of capacity and the paranoid delusion.
Your complaint about the last sentence of 75.3 is that the passage in brackets erroneously says that the decision indicated that the suggestion came from a medical professional, when the suggestion clearly comes from the husband.
Well,
That's what your submission is.
I mean, yes.
And I mean, the problem with this run of paragraphs is it's the judge descending into the ring in a way in which he is making criticism of the Ombudsman, which we say is misplaced, but in any event doesn't reach the high threshold of irrationality.
Well, that's a different point. If there's a judicial review challenge, the judge to some extent does have to enter into the ring, as we've been doing for the last 2 hours and 10 minutes. But the your point is, it's one thing to enter into the ring, the other is you say these criticisms are misplaced.
Yes.
Understand?
And certainly they don't provide a basis for meeting the formidable rationality threshold.
Yeah.
So that's 75. 76 I've addressed you on, so I won't return to that. 77. The decision, and this is particularly paragraph 1.9 of the revised provisional decision, demonstrates that the Ombudsman placed greater weight on near contemporaneous statements to the effect that concerns about capacity had been identified prior to October 2020 than he did on submissions made by the firm that capacity was not a known factor until much later. And that was entirely within what she was allowed to do. And the criticism of the Ombudsman's reasoning, that's 77, is premised on that preferring by the Ombudsman of some evidence over other not being rationally open to her to do. And we say that's
What actually is this a criticism of? Which bit of the decision? She doesn't explain why it was not adequate or reasonable. Then we need to nail down what the judge is dealing with.
Well, the references to adequacy are also at 1.18. The reasonableness reference, and of course there is reference to fair and reasonable tests. So
I was going to say that runs through it.
exactly, that's the golden thread.
Sorry.
Basically, this is a paragraph saying there should be more reasoning.
Yeah.
So to judge that, it's quite helpful to see what was the reasoning which contained those words. It's a very sparse piece of reasoning in itself.
Yes, well,
Is there any, I mean, this seems to be a criticism of what the decision doesn't contain.
that's certainly the case.
Well, it seems to start off by saying that the Ombudsman said something was not adequate or reasonable, but should have said more than that.
Yeah. Where are the words adequate and reasonable that the judge is referring to? Where are those in?
Well, we've got adequately at 1.18.
Adequate at 1.18, and we have reasonableness at 219.
But the short point is of 77. You say the Ombudsman made clear what evidence she was relying on, made clear which evidence she was attaching greater weight to, including the contemporaneous documents, and therefore it was a matter for her if she decided to place greater weight on those than, say, the opinion of Miss Khan.
Exactly, my lord. You have one point.
Yeah.
And that is the same point at 78, where there's criticism made of the relationship between documents of the 9th of October and the 13th of October, and the Ombudsman just formed a view.
Where is the suggestion? I'm sorry, we may be going around in circles. Where is the suggestion in the decision that an expert opinion capacity was necessary at September 2020? In other words,
Well, that's 1.14.
that's back to 140.
Should have taken steps earlier on the process of successive CXPO litigation. Well, I'm conscious of the time. If I may move on, I think I've addressed the relevant paragraphs now. We say that paragraph 80 of the judgment, despite its saving language, merely describes the issues with the judgment below, rather than demonstrates that they were cured. It is an unduly formalistic analysis and doesn't read the decision the right way.
Okay.
Ground 2, my Lord Justice Holgate has noted, may be bound up in ground 1 to some degree, and I've taken you to the relevant passages. The short point is this: it's not clear from the judgment that it could be read as imposing an obligation on the Ombudsman to apply legal concepts, whatever those might be. And we say that's clearly an error of law because Parliament has not imposed such an obligation. Or it might be that there is an inadequacy of reasons in departing from the law. But I've taken you to the relevant passage which we say discharges the reasons obligation.
But your primary point is there wasn't any departure.
Not exactly. This is a decision made reflecting, in particular, the Law Society guidance, and mirrors the language of the Law Society guidance in the final decision itself to explain why the due diligence obligation arose in the treatment. Ground 3, my lord.
Because I mean the key part of the judgment is 72 to 80.
Yes, my lord.
And that's all effectively matters of fact. There isn't a point of law in there, overtly at any rate.
Well, my lord, the question is, I think, this is how we put it, is if at 61 the judge has held that the Ombudsman is required to apply legal concepts, do paragraph 72 to 80 criticise the Ombudsman for departing from those? And it appears that where he's saying that there was a conflation of mental health conditions with lack of capacity, he thinks that is an error of law. And our short answer to that is that's not what the Ombudsman was doing. When I turn to ground 3, ground 3 is, as I said at the outset, potentially dispositive of this appeal in the sense.
If you were to conflate mental health issues with mental incapacity, that would be an error of law.
Well, my lord, yeah.
And particularly if you were purporting to apply that concept. You don't have to, but you could choose to. So it's an example of where you have to get the law right.
Well, if you are purporting to apply the law,
Yeah.
the law must be correct.
Yeah.
The Ombudsman has the discretion conferred by Parliament not to apply the
I
law.
grasp that.
And the mere fact that a fair and reasonable test is being applied should not be taken to presume the law is being applied.
Of course not.
Ground 3, we say, is potentially dispositive of the order of the appeal in the sense that the order of the judge below was a partial quashing order relating to the fee reduction. But as I'll take you to briefly, the judge also found at paragraph 79 that the incapacity finding of the Ombudsman was rational, indeed the only way to read the key capacity report and certificate. So what you have is a situation in which the judge has held that the basis of the fee reduction was rational, but has notwithstanding made a quashing order, and we say that is an error. To make this good, I would note that the description of redress is at 234 of the core bundle, expressly presented in the context of the recognition that CXV do not have capacity to act. A materially identical finding is made at 246.
Sorry, 234, which paragraph?
234. 234, did you say?
So I do apologise, 235.
It's 234 and 235.
So 235, you have the remedy to recognise that CXV do not have capacity to act. And 234, my learned friend notes, that's the paragraph dealing with the lack of capacity. For your note only, I'm conscious of the time, this emerges, you'll have seen the list at the start of the revised original decision of 5 heads of complaint. The first was about the adequacy of the capacity assessment. The second begins at 226. The firm had charged excessive costs for the work completed. The Ombudsman at 2.14, page 229, identifies two questions to answer that point. The second of which is, in relation to costs, did CXV have the mental capacity to understand what was being charged, the implications of her contact with the firm up to the point that the litigation firm was appointed? That's then picked up at 224, page 231. The Ombudsman finds that the paranoid delusional state and the capacity certificates together, the paranoid delusional state explains the lack of capacity, the capacity certificate reinforces that finding.
It's not about capacity alone, though. There's a lack of, it said she didn't fully understand how the costs were mounting up. Again, it's the wider concept of vulnerability again.
Well, I think on this point, the way she phrases the question at 2.14.2,
Yeah, but it's got to be read in the context of everything which has gone before. And it reads to me as shorthand.
well, it may be, but then it finds voice on page 234 and in the redress as going to capacity alone.
Well, yeah, if you go to the bottom of 234, I consider that from the outset the firm were on notice of the issues and challenges that their client faced and should have had due regard to the SRA guidance.
So well, it may be that what in fact she's doing is make an adverse inference in the absence of an assessment in the context of the wider evidence she's seeing, including the capacity certificate. But the clear statements at this point, or a potentially clearer statement at this point, 246, by the first bullet point, the firm entered into a contract with someone who did not, sorry, I say first bullet point, first whole punch. The firm entered a contract with someone who did not have capacity to act and is therefore technically void. I have therefore decided that a further 20% reduction is appropriate.
So the short point is you say that because he found a reference to the certificate that CXV did not have the capacity to act, that was the basis of the fee reduction, and that therefore all that we spent this morning on is irrelevant.
My lord, yes. And we will note this is precisely how the point was put in our consequential submissions. And we will note that is supplementary bundle, page 306, paragraphs 7 through to 12.
Yeah.
Ground 4, my lord.
So this argument rests on 79 of the judgment. But isn't there a second part to 79? Having, in the first part, concluded that the only rational interpretation of the certificate of the 4th of December was that there was no capacity, not just simply then, but going back to August. But then the contrast is the second part of 79, which says, well, that isn't dealing with how matters ought to have appeared to not a psychiatrist but solicitors in September.
Well, so you're absolutely right. There is a different point. So the adequacy of the assessment of capacity was in the revised proceedings decision dealt with under heading 1 of the complaint. The issue here was dealt with under heading 2 of the complaint. And what the judge appears to be doing is saying, well, the lack of capacity finding is rational, but somehow the other irrationality found in paragraphs 72 to 78 mean that I have to go on to make a partial quashing order, and it's not clear to us why. And this is repeated
Because he
paragraph
found
99.
that the decision on that was irrational.
Yes, my lord, but
So why would there be a further reduction? But I mean, that's the argument the other way. But it's a one line. This is a one line point.
yes, my lord.
You say.
Yes, my lord.
So you've shown us what you said in your consequential submissions, but the judge didn't accept that.
Yes. So what we have ended up with is a situation in which the basis for the fee reduction, expressly the basis for the fee reduction, was held to be rational, and yet a partial quashing order was made.
Okay.
Then is the get ground floor and costs.
Yeah, well, if we're coming to ground floor and costs, we'll pause there. One thing that I'd be grateful if you take instructions for an answer to. You've rightly made the point, which we completely understand, that what matters is that the material that was before the Ombudsman and the Ombudsman's decisions on their face, which gives rise to, speaking entirely for myself, a significant surprise on my part when reading into this case to see that there were statements, witness statements from the Ombudsman. I find that extraordinary. I'm not saying anything about the language of those statements, which I also deplore, but why on earth are the statements from the decision maker? I mean, on that basis, we should be hearing from the judges against whom there are appeals. I mean, it's just not done.
Well, if I can very briefly persist on that, and I'm conscious of the point you made. The second statement goes to the procedural history.
Yes, but that's where she uses the word nonsensical at one point. So it's not going to the procedural history, it's advocacy of the worst sort. And what about the first statement?
The first statement is in the context of a decision maker who sets out their reasons with minimum formality and very particular granular points taken against that decision. It is an explanation in particular that matters were taken into account.
But the trouble is that that's simply advertising the possibility that you haven't done it properly first time, or in this case, second time.
Well,
Which is why the decision maker, it's the first rule of any decision maker, if there's a challenge, not to provide evidence that you say the decision stands and falls on its own.
well, I take that fully on board, and you'll have noted that I haven't turned up.
Well, I understand
At any
that
point.
if I may say so, very wisely. But whatever else happens on this appeal, speaking personally, I'd be very grateful if the message could go back to the Legal Ombudsman's department that if decisions are challenged, the last thing the court wants to hear from is a witness statement from the decision maker.
Well,
Okay,
sure.
great. We'll come back at 2.
Court rise if able. Court rise if able.
Yes. You have 5 minutes on costs starting now.
May I, before my clock starts, deal with 2 outstanding questions from this morning?
Yeah.
The first is, my Lord Justice Holgate asked me the effect of breach of the Law Society guidance.
Sorry?
You asked me
Oh yes, it was only
disciplinary terms.
Yeah.
The answer I've received is breach of guidance alone is not misconduct. It may be relevant to demonstrating breach of binding regulations. Yes. And then, my lords, you asked me as to, in paragraph 77 of the judgment, where the words reasonable and adequate are used.
Yeah.
where they can be located in the relevant decisions. I've got some references which I'll rattle off if that's okay. The word reasonable is used in the revised provisional decision, core bundle, page 219, and in the final decision, core bundle, page 240, page 243, first paragraph, third line from bottom, and 246 in the fair and reasonable formulation. The word adequate is used in the revised provisional decision, core bundle 225, paragraphs 1.16, 1.18, and on page 234, first line. And then in the final decision, the word adequate is used, page 244, second full paragraph, fourth line, page 245, under the heading remedy. Not immediately clear which place is being referred to at 77, but you have the full spread.
Well, that's the real point. What was the judge referring to? Not just where the words adequate and reasonable appear, but what was it that the judge was saying which wasn't enough?
Well, my lords, I think the term reasonable is used almost exclusively in the context of the term reasonable test. So there must be looking forward with that. And the word adequate is principally used in the context of whether an adequate assessment.
Maybe it was just a labeling.
But I'm not sure we can glean anything more from judgment.
Okay, thank you.
Ground for costs are skeleton argument paragraphs 42 to 47. Ground for concerns the cost order in the core bundle, page 50, paragraph 2, whereby the legal ombudsman was ordered to pay the claimant, and now the respondent, 40% of its cost of the claim in the sum of just over £19,000. That order and the judgment at paragraphs 103 to 104 was silent about the costs expressly reserved by the same judge on the 6th of March. That's in the order misdated the 6th of May. Supplementary bundle, page 324, paragraph 10. The failure to
silent as to the reserved costs.
silence is the reserve costs.
Yeah.
And that was despite the judge having adopted an issue-based assessment of costs at the legal ombudsman's request. For your note, the legal ombudsman's submissions on costs are in the supplementary bundle, tab 39, page 309 to 313, paragraphs 14 to 21. The key paragraphs.
Sorry, did you get the reference again?
Sorry, 309 to 313, paragraphs 14 to 21.
Yes.
And the key paragraphs for current purposes are 17D, which falls to be understood in the run of 17 generally, footnote 4, and paragraph 21. In those two paragraphs, a set-off was expressly sought in respect of reserve costs, and the footnote just gives you the
So
figures.
17B talks about
17D, my lord.
that's saying about resisting the applications. And what was the other paragraph?
17D
Yeah, I've got that.
and 21, my lord.
Yeah.
So you expressly raised the question, or
Expressly raised the issue,
set off and it wasn't dealt with.
precisely. And then the footnote is there.
Hang on. You in 17B, you refer to that bit amongst other things, and then say in the circumstances the claimant should pay the legal ombudsman's costs of the applications. Costs were reserved.
Yes, my lord.
Such sums fall to be set up against the sums that may be held payable. And then in 2021, you talk about no order as to costs.
Yes, my lord, because of the set-off.
Exactly. I mean, that's the way the judge recorded it in his judgment, that you were asking for no orders to costs.
Yes, my lord. But
So the implication was that the set-off you were claiming, if it were to be quantified, would roughly equate to whatever order the other side could get on an issues basis.
well, that's pretty right. The
So
reason
in effect, that was an implicit summary assessment that you were asking for,
we especially asked for a summary assessment.
because you said otherwise
Yes,
it
the same
it
fact.
should be summary assessment. But your own submission was a broad brush summary assessment as to what your costs thrown away were worth compared to the costs that the other side should get.
Well, the reason I refer to
And what the
footnote
judge did
4
was to say, well, I assess 40%.
Well, the reason I refer to footnote 4 is because those give you the figures that we were seeking, which exceed the sum ultimately that the legal ombudsman paid across. But what we said no order of cost was just effectively, let's not argue about the difference here, let's be proportionate and say no order, because the set-off effectively knocks out the primary sum. In terms of the legal principles here, basis we say there being a legal error, if I may briefly take you to 3 cases.
No, you're not taking us to any cases on costs.
Okay, my lord.
They're in your skeleton, are they?
They are, my lord.
Fine,
Yes.
well then we'll see them there. But the short point is, why wasn't the judge entitled to do a broad brush assessment of cost?
Well, my lord, I don't deny that he was entitled to a broad brush assessment of costs. The legal error is the legal error described in Taylor and Burton, which is that it cannot be discerned from the judgment. We do not know, in the language of Lord Justice Reimer at 33 and 34 of Taylor and Burton, whether those costs have been dealt with, and if so, how.
Haven't they been implicitly dealt with, as my Lord Justice Holgate was endeavouring to demonstrate to
My
you?
lord, we submit not. What has happened is the judge has formed a view that on success alone, the respondent would have been entitled to 60%. The serious conduct issues, about which he uses heavy language at paragraphs 37 to 40 and 45 of his judgment, reduce the claimant, the firm's entitlement to a further 20% of that. But what he doesn't look onto at any point are the costs that the legal ombudsman incurred and were reserved in respect of the applications heard on the 6th of March, 2 of which were dismissed, and the 3rd of which, being allowed, caused an adjournment of that hearing.
Could you have asked for clarification on this? I'm hesitant about clarifications, as my Lord knows, but couldn't you have asked for clarifications about how the judge had dealt with that?
Well, my lord, the cost section of the judgment, so this is paragraphs 96 and onwards. If I just ask you to turn up 96, those sections followed consequential submissions and were only revealed by parties at point of handout. So we made our consequential submissions. Paragraph 96, in a draft of this judgment circulated to counsel, I invited written submissions on consequential matters. In the event I received submissions on relief costs of Bishop appeal, I'll deal with this issue here. So the horse had bolted, my lord. We couldn't ask this to be dealt with at that point.
Why not? Because you're saying he omitted to deal with it.
Yes, my lord, but he omitted.
So if your submission was right, he could have just forgotten about it.
Well, the answer is
You don't come to the Court of Appeal on something that a judge might have forgotten about, certainly in relation to costs.
well. The short point is, when the judgment was handed down, at that point, what is stated at paragraphs 103 and 104
Wasn't in the draft.
wasn't in the draft.
That's what he added, having received the
Precisely.
submissions.
So we weren't on
Yes.
notice of this.
But on the other hand, if you go to 104, subparagraph 4,
Yes, my lord.
he talks in line 3 about a failure which led to the substantive hearing being adjourned, causing cost and delay to the other parties.
Yes, my
So,
lord.
as a matter of principle, he's taken into account the costs you incurred. Thrown away. You may have said it wasn't enough, but that's a different point.
Well, we are not saying it wasn't enough, because that plainly wouldn't be a point of appeal.
No, but it,
And appeals be granted because of an error of law. The reason that we are joining issue with Roman 4 and Roman 5 is the exclusive focus on the judge in terms of the cost of orders ultimately made appears to be that the claimant then, the respondent now, shouldn't be entitled to recover its costs at the 60% mark because of its own conduct. But the associated costs of the legal ombudsman are left out of account. That's the error we say is there. We say that matches the error in Taylor and Burton in paragraph 33.
then why has he bothered to say causing cost and delay to other parties? On that analysis, it's gratuitous.
Well, my lord, he does that because that is the language that mirrors Langer and McEwen, which justifies an issue-based award of costs. So that reference for your note is
No.
paragraph 42
That
and 18 and 19.
that's not a reference to a case. That's just a matter of fact, causing cost and delay to the other parties.
Well, I'm not saying it is invoking the case. What I'm saying is that the point he's addressing in substance, inconvenience to the court, cost and delay to other parties, are the points about taking a large number of unmeritorious points, adopting an unacceptable approach to litigation, putting other parties to considerable effort, expense and delay, which inform the basis for an issues-based award of costs in Langham McEwen at paragraph 42 and paragraphs 18 and 19.
All right, well, that's that point. But that's a standalone point, is that right?
Entirely standalone.
Okay.
And it doesn't arise if you succeed on ground one, I suppose.
Well, round 1, 2 or 3, we say, should result in a reconsideration of costs as a whole.
Yeah. Okay. Thank you very much. No, thank you very much. Yes, Ms. Linfield.
Well, I wonder if I could just very briefly turn to that last point and what happened on the 3rd of March, because it is relevant just by way of housekeeping. Because the learned judge records in his judgment at paragraph 41, which is at page 61 of the core bundle.
Sorry, page.
61 of the core bundle,
Yeah.
paragraph 41, where the learned judge says, on the other hand, I was being told by counsel that the documents were of potentially critical relevance to the fate of the JR claim. I considered refusing the claimant's application would result in the court having to decide this in the dark. And then over the page, we see at paragraph 42, it says the parties' skeleton, it was not possible or sensible to continue with the substantive hearing. The parties' skeleton arguments had not addressed the documents sought to be introduced, and there was now insufficient time for the completion of oral submissions. I adjourned the case to the 12th of May, requiring the claimant to file and serve a witness statement identifying, exhibiting the documents in the supplemental bundle, distinguishing between A, those that were sent to the defendant prior to its decision, and B, those were not, and explaining the basis on which the claimant wished to rely on the latter category. And the reason in part why that arose was because it wasn't entirely clear what it was the appellant accepted had been provided by the respondent throughout the ombudsman process. And that is why in the supplementary bundle at the second witness statement of Andrea Vaughan, paragraph 7, which is at page 225 of the supplemental bundle. Sorry, paragraph 9, which is at 226.
Yeah.
We see what Andrea Vaughan confirms, what documents were before her at the time the final decision was made.
Yeah.
And that is an extensive list of documents. My learned friend earlier suggested that there weren't certain documents such as attendance notes with counsel 19th of October. We see that at little e on page 227.
All right. Well, that's
yes, that's just the context to that.
Okay. So there was a dispute about disclosure. The
Yes.
judge reserved the costs. I mean, you may as well deal with ground 4 since it's arisen. What do you say about ground 4?
Well, in relation to ground 4, we say that the judge took into account and adequately assessed in a reasonable way within his discretion what the costs ought to be, and made a 20% reduction in respect of what he considered had caused cost to the other parties, and he explicitly refers to that at paragraph 104, little Roman 4 at page 74.
So you say that was a broad brush exercise he was entitled to
Yes.
do.
Yes.
Right. Okay. slightly cart before horse, but that
It,
dealt.
it's,
But that's all right. That
Yes.
like we can tick off ground 4. So
Yes.
that's a good start. Right, over to you.
the reason why I drew attention to why the March hearing was adjourned was because there was still a lack of clarity about what documents were before the Ombudsman.
Well, it was adjourned because the documents went in late.
Yes, I have
Whether
to.
they were before the Ombudsman or not, I don't think that's a very good point.
Well, there had been attempts prior to the 3rd of March to elicit from the Ombudsman an agreed list of what it was that had been before the Ombudsman.
All right, but we're not
And
going to be
anyway,
finding that
matters
this
have
was and that
moved
wasn't.
on from that.
Yeah.
Effectively, what the respondent says is that grounds 1 and 2 are incredibly similar, and the appeal turns on one distinction: process rationality versus outcome rationality. It's accepted that the Ombudsman discretion under section 137(1) of the Legal Services Act is wide, but the width of that discretion is irrelevant to whether the reasoning by which she exercises it contains a logical error. The judge found 4 key logical errors, and the challenge isn't to the outcome she reached, it's the challenge of the reasoning by which she reached it. And the appellant's grounds don't engage with the individual logical errors, and in submissions today have not engaged with the individual logical errors, and the argument upon the appellant seems to be that there's a wide discretion, and treat that as a defence to identified errors of reasoning, but we say that the Ombudsman can't operate by the length of a foot and must make the reasoning clear so that decisions can be understood and be amenable to judicial review for irrationality. Because in the judicial review, a small firm such as Aina Law choosing to judicially review the Ombudsman was a significant step. But the reason in why she did so was because of the assertion and the insinuation of the Ombudsman that she had effectively taken advantage of a vulnerable client, and that she had not properly assessed the interested parties' mental health and her capacity as an ongoing basis.
Taken advantage of? Just
Well,
why do you say that?
That was effectively the inference that we get from the decisions of the Ombudsman, because essentially they're saying that she's inadequately assessed litigation capacity from the first meeting, and as a result ought not to have acted because of the vulnerability factors.
Is that taking advantage of?
Well, we
Taking
say
advantage of implies professional impropriety, doesn't it?
yes. Well, we say she.
Where does the Ombudsman find that?
I mean, I've noted you down as you originally said that was an assertion of the Ombudsman, but then I've noted you down as saying that that's an inference from the
Yes.
decisions.
Yes.
I mean, I think my lord is right, isn't he, that it's not put in those terms expressly. You
No.
say that's an inference you could
Yes.
draw from.
Yes, and certainly for a small firm, the principal, a very experienced family solicitor, the only way in which this decision could be challenged was by way of judicial review. And so that is why the reasoning must be clear so that decisions can be understood and amenable to judicial review for irrationality. There may be occasions where there be a decision of the Ombudsman which could be amenable to judicial review, but a firm takes the decision not to. But there has to be contained within the decision of the Ombudsman a reasoning that makes it so amenable.
Sorry, can I keep up? That sounds like a reasons challenge, as opposed to the reasons may have been legally adequate, but the reasons were irrational. And on that point, I think you made it clear this was process irrationality, not outcome. Is that correct?
Yes, but in order to understand the process, there has to be some reasoning, or there has to be, maybe reasoning's the wrong word, an account of how one gets to the decision.
To be fair to you, the cases do explain, particularly South Bucks and Save, that if there's something inadequate legally inadequate in the reasons, it will normally disclose a real possibility of a public law error. So you could link it to irrationality. But I think the point that's taken so I understand where you're coming from, but the point I think that's taken is you didn't actually plead a reasons challenge. Is that right or wrong?
The pleadings advanced rather more broader grounds than they were honed to in the skeleton argument, and certainly by the time that I was instructed, we had the initial March hearing, which was adjourned but became a directions hearing, and certainly the focus at that hearing became what will be the grounds of challenge, and how will the matter be case managed at the May hearing, and the learned judge himself indicated that in respect of irrationality, the ground was seemingly process rationality, and so by the time of the 12th of May hearing, that was indeed the focus of the respondent.
Yeah.
I should start by a number of concessions. We don't say that the Ombudsman was required to apply the Mental Capacity Act. However, we say once the Ombudsman is engaging with it, that she must apply it correctly. We accept that the Ombudsman was entitled to take a different view of the evidence from the respondent, but again, the process by which she does that must be rational. We accept that the standard of review is benevolent, and that decisions are to be read without pedantry. And if the Ombudsman had reasoned matters correctly, she was entitled to conclude if it was correct that Anna law should have done more. But we say that the errors, the process by which she reasoned the matter, she is clearly irrational, and so that's why we relied on in the lower court the difference between process and outcome rationality. And turning to tab 22 of the authorities bundle.
Yeah.
Following Commonwealth, paragraphs 55 to 57. And the key paragraph is paragraph 56 on page 526. Process rationality includes the requirement that the decision maker must have regard to all mandatory relevant considerations, no irrelevant ones, but is not limited to that. In addition, the process of reasons should contain no logical error or critical gap. Does the conclusion follow from the evidence, or is there an unexplained evidential gap or leap in reasoning which fails to justify the conclusion? And in respect of that, one has to look at how matters unfolded in the chronology of the case. The 7th of September 2020, is when the interested party first engaged with Anna Khan Law and the principal Anna Khan, and we find the first attendance note at page 5 of the supplementary bundle. In which there's an incredible.
Weren't we told by Mr. Coulson that page 5 is the same as page 10,
Yes,
and that the first meeting was in fact on the 8th, which is wrongly identified as the 16th on page 7.
yes, but then turning to page 10, which is wrongly dated the 14th of September,
Okay,
which should have been the 8th. So maybe turning to page 10.
so what's the which is the first meeting?
So the first meeting is there's the attendance note on page 5, 7th of September, and then on page 10 there's the attendance note, which is overwritten as the 14th of September. It appears that the fuller note, because they're both dated 1800, and the fuller note at 10 is more expansive.
It's the same. It's the same note.
I mean, there may be some differences, but I'm not quite clear what they may be.
I'm a bit troubled that there's an argument about basic chronology.
Yes.
This has been considered by an ombudsman about 4 different times, and it's been considered by the court below.
Yes.
It shouldn't be a matter for us, I don't think.
No.
I thought the first attendance note was the one on page 7, which was wrongly dated the 16th and should say the 8th.
No, that's. Yes, that is. Apologies.
Is that right?
Yes, the 16th, which was overwritten.
So the first meeting is on page 7,
Yes.
and the second meeting, whether it's different or not, is either page 5 or 10, but
Yes.
is the 14th.
Yes. And in the attendance note on page 7,
Yeah.
it's very clear that this is an acrimonious family matter, that the interested party at paragraph 8 flags that she has been seeing a psychiatrist, and at paragraph 2 she says that her husband's a manipulator, coercive and controlling. There are various comments made on page 8 about domestic abuse and finances and safeguarding concerns. And over the page, she's emotionally raw and needs a lot of support.
But I just could.
Yes.
I think it's clear that the second note, the note dated the 16th, but in fact the 8th, is the first meeting, because your client discussed terms at the bottom
Yes.
on page 9. Don't they?
Yes.
We require her IG and our client care letter in terms. That would surely be what you would do at the first meeting.
Yes.
So the chronology Mr. Cosman put forward this morning is correct. The meeting at the 16th is the first meeting, although it's in fact the 8th. No big.
Yes. And what then follows is the Ms. Khan is put on notice that there is a possible mental health issue because the interested party is seeing a psychiatrist. But just because she was seeing a psychiatrist and because various issues were flagged doesn't mean, it doesn't follow that she lacks capacity.
What was she? You said she was put on notice
Well, she,
of what?
well, that she had a mental health problem because she's seeing a psychiatrist. But what is also said on behalf of the client is that her husband is manipulative and coercive and controlling. And so that is also feeds into paragraph 8, because while she accepts that she is seeing a psychiatrist, she also goes on to tell Ms. Khan that she eventually realised her husband is manipulating her from the start. He's been violently controlling. She's been diagnosed with adult ADHD, has been on medication since the 4th of April, slow releasing and amphetamines by Dr. Danhauser. Her husband suspected that it was causing psychosis and wanted the tablets changed, but she believes he was drugging her with chloroform. She will agree to a psychiatric assessment of herself if he also has one. So at paragraph 8 recorded is a scenario where there isn't clarity as to the nature and breadth of any psychiatric condition, the extent to which the interested party's husband is making allegations that perhaps her mental health is worse than it in fact is. This is an initial consultation in a family case between a prospective client and a solicitor, and there was an awful lot for the solicitor to unpick, but it is clearly noted by her that she has a treating psychiatrist who, and again we see in the bundle, for example, on the 9th of October, page 17 to 18.
Have you finished with this attendance note?
Yes.
Because if we just turn over the page to page 8, because one of the initial instructions was to deal with the children. Obviously, in paragraph 12, we see the sexual abuse allegation against the father, and it's pointed out there's a meeting of social services, the professionals, police, etc., etc. Her psychiatrists are getting together,
Yes.
which perhaps might have been of some interest to those taking instructions. And then 13 says the social worker is now blaming her for making it up, saying it's not true, etc.
Yes.
Wouldn't alarm bells be starting to ring?
Well, there are various matters to unpick during this initial meeting, because all the solicitor can go by is what she is being told as an initial consultation, and then those matters were, as we see from the chronology, then kept under review by her, including consulting with Dr. Danhauser, who was the interested party's treating psychiatrist.
Do you accept that at this initial meeting there were a number of the risk factors identified in the Law Society guidance as indicating that the client may be vulnerable?
Yes, but I don't think that Ms. Khan would say anything to the contrary. There's a difference between vulnerability and lacking capacity.
Yes.
And the complaint that was made to the Ombudsman was a failure to assess at an earlier stage the capacity of the interested party. That was the complaint. So
What the guidance says is that one or more of these factors may mean that your client is vulnerable, or that they lack capacity. I paraphrase. That's what the guidance says.
do you accept that there were risk factors present which may have indicated that the client was vulnerable or that she lacked capacity?
Yes, but it was as a result of that Miss Khan proceeded with keeping that matter under review and also liaised in the first instance with Dr. Danhauser, who was the treating psychiatrist, and additionally liaised at a later stage with social services. But ultimately, this attendance took place on a video call during COVID. Information was gathered with which then she proceeded, and if what effectively, and I'll come on to address it, but what effectively the Ombudsman is saying is that at that point there should have been a better assessment. But the question that was asked by the firm of the appellant was raised in the lower court and is still not answered is what better assessment could be done on an initial consultation with a client prior to them effectively being onboarded as a client, because this is initial consultation. What was properly noted were the concerns in either direction, that the husband's saying this about me, I say that he's exaggerating it, he's manipulative and controlling. But as I'll come on to address, what the Ombudsman then conflates that with the mental health condition as lacking capacity, and that the solicitor should effectively have known that she lacked capacity. But capacity is a two-stage test. It is the presence of a disturbance or illness of the mind and inability to weigh up the information. And again, there is no evidence from this attendance note that the interested party wasn't able to weigh up information.
Yeah.
On the 17th of September, as noted by the judge, there was a remote hearing. Directions were made with an adjournment to the 15th of October and 15th of December to consider whether there should be psychiatric evidence. And it wasn't until around October 2020 that Ms. Khan started to have the concerns that she did, or heightened concerns.
Sorry, give me that date again.
October
Yes,
2020.
yes.
Which is consistent with that
Yes.
document that said by the 18th of October.
Yes.
Yeah.
And what also has to be remembered in this case, in my submission, is that this was someone who, first of all, was only deficient in one of the four characteristics in the capacity assessment, and seemingly had a fluctuating capacity. The treating psychiatrist, Dr. Danhauser, was the first port of call for the principal, Ms. Khan. There are a couple of documents which are in the bundle and which the Ombudsman had. For example, at 17 to 18 of the supplementary bundle, there is a letter from Dr. Danhauser,
Yeah.
GP, which was provided to Ms. Khan, and he actually saw CXV at home. On
Sorry,
page
can you
18.
give me the reference again, please? That's
So page 17 and 18 of the
I misheard,
supplementary
sorry.
bundle.
Sorry.
A letter to the interested party's GP on the 9th of October.
Thank you.
It was an attendance online for review, and what over the page examination. CXV was at home and displayed good self-care. Her effect was anxious and reactive. She gave a good account of herself. She was able to consider an alternative explanation for events. She had good insight and was able to consent to treatment. Over the page at paragraph 20, so over the page at paragraph 19, I should say, 12th of October, the last sentence above the fee earner, CXV was much calmer, taking all advice on board. She is clear to struggle, but as long as he keeps the children, we'll get there. I'll speak to her tomorrow. The following day, Miss Khan speaks in the morning to Dr. Thomas Danhauser for 42 minutes, in which he gives an account of having diagnosed her with ADHD, what that means. At point 6, he advised her a legal expert was needed, that meaning a solicitor.
Yes, that was in March, was it? We did that?
Yes. And
The next bullet refers to that professionals meeting we saw on the 1st
yes,
9th September. Police told that CXV had been repeatedly calling them. And then there's warning that this may turn them against her.
yes. And then he says he stopped her ADHD medication and restarted it on the 18th of September. She did not show any psychosis, so it's fine for her to carry on with it as it suits her. On the same day, CXV brought in her mother and sister
Why
to his
did he
office.
stop the ADHD medication?
I think there were concerns about the side effects upon her.
Mm.
But again, this is Ms. Khan engaging with the treating psychiatrist, who is effectively saying that as far as he's concerned, that she that she can parent well, and that at that given time he wasn't raising concerns, but over the page at page 21, 2 paragraphs up, I said we're planning to ask for both her and father to have a psychiatric evaluations. He agreed and recommended psychiatric must be an ADHD expert, maybe too much to take on the case. She needs a high level of support. However, what he doesn't say is I don't think she lacks capacity.
He wasn't asked about that.
No, he wasn't. But then again, the position of Miss Khan at that stage was that she was giving instructions, and she was able to understand the proceedings and could weigh the information. And when I come to look at what the Ombudsman decided, they very much root the sense of a lack of capacity on the basis of the disclosed mental health conditions from the outset. But in reality, it is a far more textured chronology, because the matter evolves. On the 3rd of November, there is an attendance note with counsel, where by this stage Dr. Isaacs was the jointly instructed expert to do a joint report in respect of the parties. And at bullet point 4 or bullet point 3, AK Aina Khan has an update with paragraph, so page 24,
All right, I was
3rd of
I'm
November.
still on 22 in the Scott schedule. Right, sorry, 24. I beg your pardon. Bullet point 3.
Yes.
Very
certainly-
very up and down, that one.
Sorry. Yes. Well, certainly on 22, what is notable is that CXV was able to put to one side the allegations that she wished to make, despite the perception further down the line that she had a delusional system. She was on the 3rd of November able to take advice by Mr. Harley counsel that the fact finding wasn't necessary in the case. But paragraph 24, yes, that Ms. Khan was.
Just going back to page 22E. I don't know who the dealer is, but she seems to be somebody on the team. She said from the beginning that CXV needs to be treated for more than ADHD.
Nabila is a divorce coach who Ms. Khan engaged, but again, this is still only a couple of months after instruction. By the 3rd of November, there's a jointly instructed psychiatrist who will be considering both parties' position, and ultimately, whether or not she may have had a different condition to ADHD, what is apparent from that attendance note is that the interested party was able to weigh the information that she was being given and make a decision against her delusional subset of believing the allegations against her husband, which were never tested in the proceedings. So by the 3rd of November, it's recognised that absolutely by Aina Khan law and the principal Aina Khan that and she's very at bullet point 3 on page 24 that she's concerned that the interested party is very up and down, and she needs to be honest with her, and she's can be hysterical 1 minute, upset about everything, and then much calmer, and then advises the client not to do any more work in the case, and then the interested party says she's fine, but ultimately by this point there is a jointly instructed expert, and that report was awaited.
And then later on, the 3rd of November, the work on the schedule has to stop. We deliver this advice to you for your own sake.
Yes, and then certainly what could have taken place is that the firm could have worked on the schedule despite knowing that a psychiatric report had been ordered, and that it wasn't considered at that stage it was in the client's best interest for that work to be done. Then there's the jointly.
Well, I also might have said what's quite striking is what appears on, without reading it, page 25 in the bold type. Basically saying that the client is not listening to the solicitors and they're going to note down every time this happens.
Yes. But the general thrust with counsel there and in agreement is that they wait for the psychiatric assessment. But certainly at this point, the client is taking on board the advice that she's given. And that's the 3rd bullet point up from the bottom. CXV says she's upset, she's been called mentally ill everywhere. CXV understands we're acting in her best interest. CXV knows we've advised her the best possible way. And that was in response to the suggestion that they shouldn't go to a fact-finding hearing.
Was this the same day as the Dr. Isaac's assessment?
No, Dr. Isaac's assessment then follows. So that's the 3rd of.
Can't see when the actual assessment took place. The report dated the 12th, isn't it?
Yes.
When was- that's the
Unfortunately, the report is at page
Well, if you
7.
go to page 29,
next- It said.
there's documents, and then about by the first hole punch.
Oh yes, I
Oh,
missed
yes.
that. That's my fault.
November.
Sorry, thank you
It's a
very much.
little hidden.
Sorry, my mistake. So it was a week later, 8
Yes.
days later.
And so they were waiting for this report to be prepared, which sounded the alarm in relation to capacity. At page 51,
Not able to fully engage with proceedings.
yes.
Yeah.
And as a result of that, because this was again a client who was resistant to any suggestion that she was mentally unwell, and that she had the difficulties as she said, and so this evolved in a way where in October there were the concerns starting to creep in about an escalation of her behaviour. We have the mid-October hearing where this report is directed, and then the parties list an urgent hearing because what was then needed in the context of the family proceedings was for there to be then a joint instruction in respect of capacity. And so what is perhaps missing and why there is the process rationality is this context of evolution of the interactions with the firm and the interested party, who is saying the exact opposite of that she doesn't have a mental health problem and that she doesn't understand the problem. But following that jointly instructed expert report, there is the letter which is seized upon by the appellant. That's the 19th of November 2020 letter, pages 53 and 54 of the supplementary bundle, in which there is properly explained that there needs to be a further instruction, what that will look like, and then on page 54 under the 5 points 1 to 5, I would like to make it clear that I do consider you have capacity at the moment, but in the past I feel you have perhaps lacked capacity at certain points on and off. So your barrister and I would like to know for sure that at the times you might lack capacity, if that ever happens, that we can speak to your sister to be able to give instructions on your behalf. I'm happy that you feel so well supported with a proactive strategy by me and my legal team, and also grateful to my family coach Nabila for the out of hours support we've given you. I'll work alongside you to ensure you have the best legal support. And then do feel free to contact me if you don't understand. The next day.
Can I just ask you about, I may rather here on page 54, the sentence, I would like to make it clear.
Yes.
When Ms. Khan refers to, in the past I feel you have perhaps that capacity at certain points on and off, would it be right to read that as her own impression of what she has felt during the period of the instruction from September to this point?
That is the ordinary reading, but it doesn't say you have lacked capacity, it's you have perhaps at certain points.
Well, in other words, there was a doubt about it.
Yes, but by the 19th of November, there was already the report of Dr. Isaacs in which the alarm had been raised.
Forgive me, that's why I asked you about this sentence. As I read it, and I think you've agreed with this, what Ms. Khan is saying is that at times during the instruction, I have felt you have perhaps lacked capacity at certain points. Is that fair? Is that I think you've agreed.
Yes.
Please
well,
say
yeah,
if I've misunderstood
is-
you. That
but not as but we have to root when that might have been, because it certainly wasn't early September.
Well, it doesn't
Because-
say,
No, it doesn't say.
and it's
and
not.
in-
We're not in the Chancery Division.
at certain points.
But it also has to be read in the context, in my submission, of a client who is resistant to any notion that she's got a mental health problem, resistant to any notion that there's an issue around her mental health and her capacity. And so this was a letter to the interested party to effectively soften the blow of the fact that there needs to be a capacity assessment. However, what we do know is that the originator of that letter is the joint report by Dr. Isaacs, which was commissioned mid-October, when Ms. Khan starts to be concerned about the interested party's mental health condition, but is getting conflicting reports between her treating psychiatrist, the interested party, this idea in the background that some of the reports about the psychosis are actually in fact generated by the opposing party, who's the husband, who Ms. Khan is being told is financially and emotionally and potentially sexually abusing the family. And so to make it's an evolution. And the notion that in early September, this was an assessment that a solicitor could make. There is a process precisely for this.
Let's see if I've caught up with this. By the time this letter's being written, an instruction has been given to Dr. Isaacs following his first report to do a capacity assessment.
Well, what's the matter is in court the following day on the 20th. So I write to you after the hearing. Yes, it's just
Well, the
dated
letter
on-
is a bit strange because
Yes.
it's dated the 19th of November and talking in the first sentence about a hearing on the 20th.
It's misdated. I think there's an
But-
issue with the software.
More software.
But
Right.
it's
That-
by the,
But we're in at this stage, round about this stage, an instruction's being given to Dr. Isaacs to do a capacity assessment.
yes.
And then we come to this paragraph we've been looking at. I would like to make it clear. You have capacity at the moment, but perhaps I felt you've lacked capacity in the past. That's not an offhand comment because it leads to the next sentence. So, your barrister and I would like to know for sure that at the times you might lack capacity, if that ever happens, can we go to your sister for instruction? But it's in that context that the author has written the previous sentence saying, I feel you have perhaps lacked capacity. That's not a throwaway remark.
Well, it's what Ms. Khan would say is it's since October when
All right.
well anyway
There
yes,
it is.
but we do see over the page 55 an attendance with the KC involved instructed. And there's over the page 56 no part 25 to be done in relation to any guardian or independent social worker and that they await the report and the hearing on the 15th of December.
Can I ask one point about something you said a couple of times, Ms. Linfield? It's this. You've asked us to take into account the fact that the IP, independent interested party, the client, was wholly resistant to the idea that she was ill. I paraphrase what you've said. What effect does that have on the solicitor's responsibility when considering vulnerability and capacity? Does that reduce, as it were, the concern, or might it not be said to raise the concern if there's evidence of mental health problems which the client is denying?
Well, I would say it is a fact-sensitive exercise,
Of course, yes.
and certainly in this case there were very serious allegations being made by the interested party, and serious concerns being raised in respect of her husband. I should also say that in respect of concerns about her husband, that was something that also came out independently of the interested party, and was in fact raised by Dr. Danhauser in the 42-minute consultation on the 13th of October, which is at page 20.
Yeah.
Because he says that there was it's A and B, the first A and B, marked deterioration in her after lockdown when F was home full time. Within days of him leaving the house, she bounced back to herself. So there are a multitude of factors that are having to
We
be
get
weighed.
that.
Yes.
We get that. Do we need to carry on looking at
No, I hope
the contemporaneous material? I mean,
no, because I think that really runs its course, because then, of course, we get to December and the litigation friend is instructed.
Yeah.
And turning to the reasoning of the judge, the page 57. Of the core bundle, which is the paragraph 25, which we haven't turned that up. I don't propose to. I don't think it's controversial to say that the summary of the provisional decision was that the claimant had not adequately assessed the interested party's litigation capacity, and the costs had been charged been excessive. And in respect of the litigation capacity, an award of distress was made in the sum of £1,000. And then by the 28th of November, we then have the revised provisional decision, which substantially changes the award in respect of capacity, and notably what is said by Miss Vaughan in respect of that is that she had taken legal advice from, there's a letter at 217 of the core bundle.
Yeah. That's sending the revised provisional decision.
And then at page 220, which is the provisional decision, although it's the revised provisional decision, at the top of the page, I apologise for the delay in making this further decision. After discussing this file with our legal team, they brought an issue to my attention which is why it took longer than it usually would. We don't know what that went to, but we do know that the fee refund changes, page 235 of that core bundle, a 20% fee reduction to recognise that CXV did not have capacity to act. And so it seems to be, after this, the first provisional decision, that the notion of ability to contract finds its way into this decision, which is relevant to ground 3, and I only flag that now for later. But the complaint, and in my submission, it is necessary to have it firmly in mind that the complaint was that the firm failed to adequately assess CXV's litigation capacity, but the revised provisional decision does allude that the issues of mental health being effectively that there is a lack of capacity, which is what, in my submission, the judge was correct to find. At paragraph 47 of his decision, which is at 63 of the bundle, of the core bundle.
Well, that's your submission. He's
Yes.
He's recording your submissions as to why the decision was irrational, and that's the first. That was the first point, and obviously that's a point that it remains of great importance to you now.
Yes.
Yeah.
However, he does accept those submissions, because at paragraph 74.
Yeah.
At 68, he says, I consider the decision did conflate indications of mental health conditions with indications of lack of capacity, or at best failed to keep the critical distinction between those two concepts in mind. Paragraph 1.14 of the decision specifically recorded that it was clear from the outset, as I have outlined in 1.3, that the interested party was suffering from mental health issues from the first meeting.
Yeah.
And we say that is an error that goes through the decisions, and that is not, first of all, is not accurate on the facts, but also in respect of the law, and that's why ground 2 is of course relevant to ground 1, because what the Ombudsman did do was engage with the concept of litigation capacity. However, we say that she misapplied or that she got the law wrong when she considered that a mental health condition equated to a lack of capacity.
Well, what the judge doesn't do is actually quote all the relevant text in 114. He stops at September 2020 and then goes on to say at page 225 of the core bundle, we should have taken steps earlier on in the process to assess if she had litigation capacity. So he hasn't assumed that because there are mental health issues, and it's just a misquote.
Well,
or an incomplete quotation. And he goes on to say, ironically, the mere fact that she had mental health issues begs an important question. Absolutely right. But if one goes back to 114, there is the question begged, which it is said should have been, rightly or wrongly, should have been considered.
well, that isn't the only error in relation to that conflation, and in fact, when what is particularly pertinent is that in the Ombudsman's first statement, she addresses
Is in the
these
supplemental
criticisms, yes,
in the supplemental bundle.
in the supplemental
tab
bundle,
32.
tab 32, where she deals with the criticisms of the decision, that CXV paragraph 21, 216, that CXV lacked litigation capacity from the outset. And she says that was indeed a conclusion which I reached. See RPD 1.11. However, the significant point for the purpose of the decision was failed to adequately assess CXV litigation capacity. But interestingly, at the bottom of that paragraph, she says, in particular, had regard to the evidence about the first meeting as to CXV's mental health, as recorded in the firm's own attendance note. However, at no point does the Ombudsman indicate what better assessment a solicitor should do at that stage in proceedings.
Could we go to what may be the kernel of the Ombudsman's decision at 117 on page 226?
Yes.
And the last 4 lines of 1.17. My view, and help me to know where you say, if you say, if so well, Ombudsman was wrong here, in the sense, and I think you have to say irrational. My view is that there were indicators present at the outset, and that they should have taken steps from the start of the instruction to confirm if CXV had capacity so that the right support should be given, etc. Do you quarrel with that phrase, those phrases? There were indicators present at the outset?
Well, there was a possible mental health condition, but the indicator of a mental health condition doesn't then follow that there has to be a capacity assessment, because the obligations, and this was raised on behalf of the respondent, the obligations very clearly under the Mental Health Act, or Mental Capacity Act, are, and that's tab 2, and I know my Lord Justice Baker is very familiar with the Mental Capacity Act, as are my other lords, but the following principles apply for the purpose of the Act. A person must be assumed to have capacity unless it is established that he lacks capacity. A person is not to be treated as unable to make a decision unless all practical steps to help him do so have been taken without success.
Yes.
But
the fact that there is a presumption of capacity and all the protections built into the principles in section 1 of the Mental Capacity Act doesn't absolve a solicitor from the responsibilities set out in the guidance. When one or more of the factors are present, it may mean that your client is vulnerable and may indicate that they lack capacity. And what the Ombudsman said here is that there were indicators present and that they should have taken steps from the start to confirm if the client had capacity. So why was that irrational?
because they've elided a mental condition with a lack of capacity, and this is a professional judgment on behalf of a legal professional to weigh into the balance what she is presented with and consider whether at what stage there needs to be assessment. It has to be remembered that the initial meeting was over Zoom in lockdown, and various things were presented to the principal solicitor, a number of which contradicted themselves. And so if there was an urgent hearing on the horizon, there was not sufficient basis for there to be a need for a capacity assessment at that point. And actually, that would have placed the interested party in such a precarious position, because she would have attended an urgent hearing at which her husband was saying that her children should be removed from her care, and as an assessment of capacity, if it were needed, which Ms. Khan would say it was not, would have rendered that hearing markedly. Either Ms. Khan would have said, you've got a mental health condition, there's a vulnerability factor, and therefore I need to instruct a psychiatrist, we can't represent you at the next hearing. That's not legally, that would, in my submission, cut across the Mental Capacity Act, because she's to presume her capacity. And at that stage, the position of Ms. Khan was that she didn't think she lacked capacity. We are looking at this, and that was one of the other factors that the judge considered in the court below. We are looking at this through a retrospective lens. I'm
afraid in this court we always are.
Yeah.
We do our best to, put ourselves in the position looking forward. But of course, inevitably we are.
And we have to be very careful. Particularly those of us that have practiced in this field, because we're not judging. I'm not judging Ms. Khan's conduct. We're not judging Ms. Khan's conduct fresh, we're considering whether the judge was right to decide the ombudsman was irrational, and that's the question here.
Yes.
Not whether we think Ms. Khan was right and what she did. But we're focusing on, our role is a very narrow one.
Yes, but a lot does turn on this initial meeting.
Yeah.
And in respect of a note of an initial meeting, if there are no capacity issues identified, they wouldn't be noted. Capacity is assumed, and whilst you might note down, as Ms. Khan properly did, the issues around alcohol consumption, the cross positions in respect of the interested party's mental health, and the allegations she made, it wouldn't be a case that a solicitor would have to note down and I found they had capacity, because that is presumed, and certainly as I've taken, I won't press the point, but then looking at the chronology, that does get assessed, that is kept in the mix. There is consultations with counsel, consultations with the instructed or the treating psychiatrist, taking a very different view, and paragraph 1.14. I think we have, reading that in the round, page 2.25, 225, to make a decision on this complaint, I have to consider that if, when CXV first contacted the firm, there's anything to give them an indication she couldn't give instructions. From the evidence provided, the first point of concern was the meeting in September, and it was clear from the outset she was suffering from mental health issues. That isn't enough. That isn't enough for there then to be engaged a level of assessment by a solicitor, and that's my own friend was careful to look at the various factors that the learned judge found were a feature of process of rationality, and it's in my submission they need to be read together to consider that putting them all together, they are that there was an irrationality of process, because again, looking at the second reason, well, actually, just turning to the point that is made in the last sentence of paragraph 74, in my judgment, the defendant needs to address and explain at a minimum whether those issues had consequences such as to require a reasonable solicitor to have doubts about the potential client's capacity, and if so, why? Because, and this is perhaps where this whole case has taken on a life of its own, because it has become incredibly granular in the way that it was considered by the Ombudsman. And there does seem to have been what my learned friend termed a sort of a fact-finding exercise, because looking at attendance notes and extrapolating out from that a mental health issue means that a solicitor should have done something different. In my submission, the learned judge was correct where he says that whether those issues had consequences such as to require a reasonable solicitor to have doubts about the potential client's capacity as of that date, putting to one side everything that then was subsequently known. And then secondly, looking at paragraph 75, the defendant in its decision placed reliance on 3 particular facts as justifying the view that the claimant should have done more to assess the interested party's capacity at the outset of the retainer. First of all, the fact that she'd been referred to a psychiatrist. It was clear from the attendance note that she'd been referred to a psychiatrist, certainly so far as she understood it, and without wishing to then go into hindsight, what then became apparent from a discussion with Dr. Danhauser because of adult ADHD. And it wasn't wrong for the judge to conclude, being referred at little 1 of 75, being referred to a psychiatrist does not of itself indicate anything about capacity. There are a multitude of reasons for seeing a psychiatrist. Many people receiving assistance from a psychiatrist are likely to have capacity to seek and receive legal advice.
The trouble with a lot of this is it's all been looked at in silos. I mean, capacity is a consequence. Capacity is a consequence of, effectively, mental health issues. You can't have a lack of capacity unless you've got mental health issues.
Well, unless you had a brain.
Okay, but in this case,
yes,
so the question is whether the two things were elided, which you dealt with, or whether the Ombudsman was entitled to say, well, these were the signs that should have been acted upon. I mean, that's the real issue. Everybody gets that the mere fact that somebody goes to a psychiatrist or has mental health issues is not of itself, seen in a silo, a sign of lack of capacity. So that's a windmill that I don't think anybody needs to tilt at.
but the defendant's decision was that more should have been done at the outset, and the fact of those 3 things, which were the psychiatrist, the fact that she was taking amphetamines, which again, this was prescribed medication for adult ADHD. There was no suggestion that she was taking street drugs. 1 and 2 go hand in glove because she's got a treating psychiatrist who's prescribing her medication. And so then we go to number 3, which is that the interested party potentially had psychosis in September 2020 at the initial consultation, but then that attendance note notes that this was an allegation made by the interested party's husband,
Yeah.
and that should not have been ignored in an analysis of the question of capacity after the event, because it goes to the process by which it is then found that at the outset of the retainer, there ought to have been a better assessment. And then the 76 relevant considerations, my learned friend at 76 little one, that the IP had consulted the claimant on an urgent basis as respondent to proceedings very recently commenced by the husband, whilst my learned friend points to the fact that that was known by the Ombudsman, we say that the judge was correct because that wasn't grappled with. This was
Sorry.
76(1),
Yes.
that the IP had consulted the claimant.
Oh, so it wasn't grappled with.
No.
I misheard you. Sorry.
Yes, because again, the question is whether or not she should have done more at the outset of the retainer. The context of the retainer is relevant. Is relevant in the process because this is someone who's coming to a family solicitor, highly distressed, has had to ask her husband to leave the property, is very worried that that there's abuse being meted out against the children, and is very aware that the matter's soon to come to court. And so, again, that then feeds into 76(2), that divorce and family proceedings often involve individuals who present from the outset as distressed, emotionally raw, depressed, or even in some cases delusional. To look back again, as we say, at that initial consultation and to not take into account these relevant considerations as to what, on a reasonable service level, because if that's what we're considering, on a reasonable service level, and whether or not within the range of options that were open, that there was a compulsion for there to be an assessment.
It's getting a bit high, isn't it? What you are saying is this, isn't it? That clients coming to visit Ms. Carr, family practitioner, in these circumstances, often present with a variety of problems, a spectrum of problems like this, which happen to be in the list in the Law Society's guidance. That's a very common, more common perhaps for people going through the crisis of relationship breakdown than it may be for other clients in other areas of the law. And you're really saying also, aren't you, that there's an big element of hindsight here. Hindsight, once you get the capacity assessment, everything is being viewed through that prism.
Yes.
When at the time, Ms. Carr was simply faced with a client with all sorts of problems of the sort she faces every day of the week.
Yes.
That's your point, isn't it?
Yes.
But that's not the question for us. The question for us is, was the Ombudsman rational?
I mean, a strange thing about 76 of the judgment is that it reads as if, I mean, the language of failing to grapple with is the language of a reasons challenge.
Yeah.
Yes, although the process by which the Ombudsman concluded that there ought to be more inquiry was because of the mental health issues from the outset, and then she then goes on to say, and the capacity certificate only fortifies my belief that at the outset the mental health factor meant that she lacked capacity. But in considering that the process of that rationale, to look at, when one's looking at, again, a service level complaint against a legal provider, to look at a capacity certificate, indications of mental health issues, treating psychiatrist, alcohol, potentially alcohol misuse, to then find retrospectively that Ms. Khan ought to have done more at the initial meeting is an irrational process, and that these factors just again shine a light the over reliance on the particular facts and the failure to take into account relevant facts is the process irrationality, because there is a critical gap and a logical error, because the critical gap is what takes place between the 7th or 8th of September and the December hearing. And the critical gap is these relevant considerations.
So, it being charitable to the judge, even if it looks like it's a reasons challenge, you can add these 4 factors together. They really he's addressing the rationality, a process rationality challenge.
Yes.
And if these factors had been taken into account, the Ombudsman could not actually come to the conclusion she did.
Well, it's the process. The flaws, he says at paragraph 80, the flaws in the decision to which are referred are fundamental and expose them as irrational in the required sense.
I mean, in one way of putting the point is, yes, there are the things to which the Ombudsman did have regard. For example, the 3 matters in 75. But if you add into the mix the 4 matters in 76, the conclusion is that someone in her position could not rationally have come to the conclusion that there could have been further investigations right from the outset.
Yes, and that
There's a bit of decoding required to get there, but that's the thrust of what you're saying. Forget that it looks like a reasons challenge. It's really part and parcel of an overall rationality challenge.
yes.
Reading the judgment as a whole.
Yes.
Oh, and also I think when you look at paragraph 77,
Yeah, there's the word rationality does appear rational, does appear at various points in this concluding paragraph. It's paragraphs, but
Yes.
not at 76.
no, but at 77, he sort of
That's why
sweeps up.
I said to you earlier on, sometimes when you present a reasons challenge, the legal analysis is it raises substantial doubt as to whether there's a public law error. That's why it is here, rationality. Could these matters properly have been taken into account and still considered? Yeah, that's the way you're putting it.
Yes, and I think 77 and 78. 77 really goes then to the point with, well, the decisions don't explain, nor have we had any explanation from the appellant, this court or the court below, why it wasn't adequate or reasonable for Ms. Khan, an experienced family law practitioner, to consider the IP's mental health for herself, considered the IP did have capacity, albeit she was in distress, some have some mental health issues, checked her own view with that of leading counsel, and then as a result of that,
about the criticism made by the other side of the last few words of 77, to have checked her own view with that of leading counsel, it said, well, that came from material which wasn't before the Ombudsman.
that was before the Ombudsman, because if we look at
not the document that was referred to, but another document.
Yes, absolutely, because if we look at Angela Vaughan's second statement, that was the exercise that was conducted after the March hearing. We then see there's a raft of attendance notes with counsel, both leading and junior counsel, where there is a strategizing about how to deal with the competing factors, frankly, in what was a very fast moving case. There were
So the short point is there was some other document which dealt with that point.
absolutely, and again, and then that then follows on to I can see no rational explanation. The decision for the suggestion that an expert opinion on capacity was necessary as early September. However, in due course, the claimant did consult an expert, and that's when we then have the Dr. Danhauser, and that the focus of the defendant at 1.8, because Dr. Danhauser's 9th of October letter confirmed there was an issue of mental health, and if there wasn't, I'm not sure why at that point the IP was taking amphetamines and was seeing a psychiatrist. If a mental health condition was not present, we say that goes absolutely squarely, and that's at page 223. That goes absolutely squarely to this point of the mental health condition being elided with capacity, and in my submission, the judge is absolutely correct to say this passage of the decision is, in my view, a clear example of the errors in the logical reasoning which are described in the cases about irrationality, and the logic is, with respect, difficult to follow. And the evidence before the defendant made it clear that the IP was taking amphetamines for her ADHD. And more fundamentally, defendants focusing the passages on the wrong issue.
And you rely on the last bit of 79 and 80, don't you?
Yes, absolutely.
Because you say that we look at that, the analysis as a whole, and that, yeah.
Yes. And also, there's also another point to note. Well, there's 2 points to note. The fact that the Ombudsman, before Ms. Khan put in any further evidence in the court below, put in their own statement trying to shore up or make good, it again shows that there is, in my submission, a lack of rationality about the process. Because if it is clear, Ms. Khan saw the interested party on the 8th of September, and there's a clear attendance note that says, I was telling her this and she just really couldn't understand, and I'm worried that she doesn't understand. She raised something with me that was hard to follow. Then that might be different, but we're not there. Added to that is the fact that we've got an interested party who was only one of 4, and that was failure to understand her delusional system was the reason why she was said to have lacked capacity, and she quickly regained capacity once her medication was sorted out. So this is, again, a somewhat textured position, but what is not clear in terms of the irrationality of the process and is the way in which the first decision awards a compensation in respect of the lack of assessment. The second decision, now it is said, awards a fee reduction as a result of an inability to contract, and that therefore in effect grounds 1 and 2 and everything that my lords have heard today is somewhat irrelevant, because the Ombudsman is home and dry on that point. But
yeah.
So in respect of ground 3, we would say that that's also relevant to grounds 1, because again, it is not easy to follow the Ombudsman's process, and what in my submission.
Well, there are 2 different points there. I mean, the fact that there was a change between the revised provisional decision and the final decision, provided that the second figure is explained on the 20%, that of itself is not a ground of complaint.
No, save for it does appear to disclose, again, an inability to understand capacity because it relates to a capacity to contract. And Dr. Isaac's capacity certificate relates very specifically to the family proceedings.
In which the interested party was instructing the firm to act.
Yes, but the fee reduction is now said to relate to an ability to contract.
But it's not.
I mean, the whole point of this terribly quick process that I think only took 3 years, the purpose of it, as I understand it, is to do away with legalism and formalism, also, as I understand it, this was put as effectively as a favour or as a plus for the firm, because otherwise the contract would have been void. That was an alternative. Instead, she knocked off 20%.
Yes, but the question would follow that if the interested party didn't have capacity to contract in September, there's either a contract or there isn't. She either has capacity to enter into one or she doesn't.
Well, but if it was void, then there might be all kinds of nice questions as to what the consequences of the contract being void are. But it might be a lot worse than a 20% reduction. I think it's the point the Ombudsman was making anyway.
But
anyway, you say ground 3 is also relevant to ground 1.
Well, in the way that it is now said that in any event, the fee reduction simply relates to the contract, whereas it is very clear.
Well, I think it said the fee reduction relates to the incapacity certificate, which goes back to August.
Yes.
So I think that's how it's put. So I think it said, forget about grounds 1 and 2. There was no entitlement to this reduction. This deduction wasn't rational because of the incapacity certificate. You make the point that the certificate relates to the proceedings, not an ability to contract with the solicitors.
Yes, and additionally, and this was something that wasn't litigated in the court below, and paragraph 79 arose as a result of a request for clarification by my learned friend, whereby because there had been a decision in relation to process rationality and the partial quashing of the decision in respect of the fee reduction of 20%, my learned friend sought clarification from the judge as to his view of the certificate, but certainly there was no finding or extensive consideration of the certificate, because if there was, there would be various points to make in the other direction, not least that Dr. Isaacs had not met the interested party until October, when she was, on anyone's views, in the throes of the most difficult aspect of her mental health issues, but also that Dr. Isaacs was jointly instructed by both parties in a previous joint instruction in which he had front and centre the allegations made by the husband in respect of the interested parties.
But is this a challenge to the certificate?
Well, the point is that
I mean, it a fly on the wall in this court would be pretty staggered at the sorts of points that are that emerge. Paragraph 79. Do you say that it was added? What, to the draft judgment?
Yes, as a result of a request by my learned
The
friend.
whole of 79.
Yes.
So, but what follows? What are you saying about that?
Well, because that point was not something that was argued fully in the court below.
What point?
The concept that the 20% fee reduction could survive whether or not there was found to be an irrationality of process in respect
This
of
isn't
need for
dealing with the 20%. This is dealing with the point about the certificate and saying that the defendant, the Ombudsman, was entitled to rely on the certificate to conclude that the interested party had in fact that capacity since August 2020.
Yes, but what the appellant now urges is that because there was not capacity at the time of the contract, that because the fee reduction is expressed in the revised provisional decision following the Ombudsman having taken legal advice from the legal team, that at page 235, which is the revised provisional decision, a 20% fee reduction, 15,692.60 to recognise that 6B did not have the capacity to act. However, that is not the way in which the Ombudsman looks at the complaint, which is the complaint is about assessing capacity. The decisions relate to assessing
not the fact of the incapacity, but assessing incapacity soon enough.
Yes, and
this additional award, the 20% reduction, is under that heading. Is
yes.
Your point.
And that's what prompted paragraph 79, because
Which is why halfway through the judge says, having interpreted against you the effect of the certificate, he then decides in your favour. I don't think that saves the decision from being irrational,
yes.
because he's actually then addressing what was the complaint before the Ombudsman, which related to assessment by your client of incapacity.
Yes.
Soon enough.
Yes.
Yeah. For my part, I have difficulty with ground 3 for that reason, because it's dealing with that paragraph is dealing with two different things.
And then in relation to ground 2, which whilst I do note the similarities between them, there's a key authority which my learned friend did not take my lords to, which is linear, which is behind tab 27, 626 in the authority bundle.
Paragraph
101 at 654. Which was in relation to, and again in this case there'd been a decision of the Ombudsman. They then took legal advice and reduced the contributory negligence to nil. But at 101, I therefore consider that the Ombudsman's decision proceeded on an inaccurate approach to the law of contributory negligence. Whilst I fully accept that the Ombudsman was not obliged to apply the law in this respect, he was obliged by DISP 3.6.4R to take it into account. That implies that he should take it into account accurately. Moreover, according to the principles in Heathermore, as explained in Options UK above, if the Ombudsman was departing from the law, he ought to have explained why. I do not consider that he did either of those things correctly, and the judge was wrong to hold otherwise. Again, my learned friend took you to...
so what do we get from that?
Well, what we get from that is there was a concession made by my learned friend at paragraph 61 of the judgment at page 66 of the core bundle.
Yeah.
Where the judge finds it does not follow, however, that section 137(1) and or rule 5.37a mean the defendant is entitled, when deciding what is fair and reasonable in any given case, to make mistakes about the correct and established meaning of legal concepts when it is choosing to apply those concepts in the exercise of its judgment. I put to Mr. Cosman a hypothetical and admittedly extreme case.
We've looked at 61. Yes. You were answering my question. What do we get from paragraph 101 of Linear?
What we get is that in this case, what the Ombudsman says is, and what is said on behalf of the Ombudsman in this appeal, is that the Ombudsman is not bound to apply the law, doesn't have to apply the law on the Mental Capacity Act, but in my submission, having engaged with it, she is then under a duty to apply it correctly, and she does engage with it to the extent that she references in her provisional decision that the matters that she had been drawn to her attention.
Having engaged with it, she's under a duty to apply it correctly.
Yes, and
yes.
so.
And where in the judge's reasoning on rationality does he say she didn't?
Well, again, in my submission, it's hand in glove with his criticism that the Ombudsman had elided a mental health condition with a lack of capacity, because
doesn't that link that to any legal concept?
No.
He just says that was an error.
Yes.
Of eliding those two things. He says they're different. One understands that. But where does the judge criticise the Ombudsman for engaging with a point of law and then not applying it correctly, or engaging with a legal concept and then not applying it correctly?
Paragraph 47, my lord, page 63. Of
47?
Yes. Oh, sorry, that's not, that's my submission. Sorry.
47. We've been over this. 47 was your submission.
Yes.
61.
No.
And 61 is at the moment, on the face of it, without trying to read this too legalistically, and trying to read it in the round, 61 is a passing comment that doesn't seem to go anywhere on the judge's reasoning. Or is that wrong?
Well, the position in the lower court.
Another way. If 61 hadn't been included in the judgment, you are taking a point, for example, about 74 under the irrationality argument, that the Ombudsman equated mental ill health with mental incapacity.
Yes.
If that's what he did, it was an error. She did, rather, beg your pardon. It was an error of law.
Yes.
You, as an Ombudsman, you're entitled. You should take into account the law, but if you do that, you have to understand it correctly. And if you want to depart from the law, equally, you must understand it correctly.
Yes.
And in a long-winded way, that's all 61 is doing. And that's what Lord Justice Snowden put rather more elegantly and crisply in the judgment you took us to.
Yes.
But
he was in, I think it was.
Yes, it was, yes, no. Because of the elegance, I thought it was Lord Justice Nugent, so I apologise. I apologise to Lord Snowden of Redcar, as he is about to become. Redcar. Born and brought up in Redcar. We'll all be very pleased when we're writing out his judgments that we'll be able to refer to him as Lord Snowden of Redcar, which is nice, short, and everybody will be able to spell, unlike some recent members of the Supreme Court who seem to have chosen villages with almost impossibly long names for us to write out.
Want to give some examples of that?
I don't.
Red car's on the Northeastern Circuit.
It is.
The point you're going to make.
It is.
Anyway, Lord Snowden.
Yes. All right. Well, that's good. That's why, though, you said earlier that ground 2 is really bound up in ground 1.
Yes.
It doesn't seem to me to be a standalone point.
Well, my learner friend takes it as a standalone point, but
They do. I'm just telling you that for my part, I don't think it's.
So you're entitled to feel a bit cross if we're taking you off for the fact that he's taken it.
Yeah. Well, but I would say that in many respects, it just demonstrates that similarly, the Ombudsman's position seems to be that they can depart from the principles of the Mental Capacity Act and arrive at decisions on a service level complaint where there has been the completely correct criticism about conflating indications of mental health conditions with a lack of capacity, because effectively what the effect of that is that solicitors are being cautioned on a service level complaint to do something which they are specifically not supposed to do, which is to go behind the presumption of capacity.
Well, I'm having trouble with this. There seem to be 2 points here. Let's ignore the wider concept of vulnerability for the moment. You've got a client and you've got a solicitor. You've got the presumption. And the legal guidance from the Law Society is that as a solicitor, if you have doubts about capacity, it's something you should investigate. Now that is not overcome, is it, by the presumption in favour of mental capacity? If it is, who on earth is going to pursue the issue, if not the solicitor?
Well, what we say is it is a delicate balance, because in the family procedure rules, it is in the practice direction 15B. There is that is at page tab 5, page 89 of the authorities bundle.
So tab 5.
Of the authorities bundle, page 89.
And look at rule
1.3. Practice direction 1.3.
sorry, you said tab 5.
It's in my tab 5. It's page 89.
Thank you.
Paragraph 1.3 of the practice direction.
Practice direction.
So it's not a rule, it's a practice direction.
It is, yes, but similarly, so
Well, in this case, that might be a vital distinction.
So in which bit? Which bit are you referring to?
I wonder if I could just develop my point, my lord. That it says if at any time during the proceedings there's reason to believe that a party may lack capacity to conduct proceedings, and the court must be notified and directions sought to ensure its issues investigated without delay. And then it says the presumption of capacity should not be forgotten, and that is a legal principle. It's borne out by statute. For example, where a person has an identified difficulty, such as a learning disability or a mental illness, that difficulty should not automatically lead to an investigation about that party's capacity to litigate. Where a party has a solicitor, the starting point is where that solicitor has concerns about the party's capacity to litigate. And that is why the retrospective consideration of a attendance note in September that gives rise to vulnerability factors, but it's ultimately for the solicitor to consider. And if the Ombudsman is placing an onus on solicitors to effectively be constrained and to do an assessment of type unknown, because it hasn't been specified, of their clients where there is a mental illness, then in my submission, that cuts across the presumption of capacity, and it cuts across what a solicitor should do. There's also a duty not to discriminate. These are very textured matters that bear upon each other, but it's not like one point is the bright line that there's a mental health condition. There has to be some assessment, because what the potential impact of this is that, particularly in family law, any solicitor who has a client who comes to them with a mental health condition may go the step too far in assessing them where it's not needed, because of a concern that further down the line, in a case, for example, of this, where there's fluctuating capacity, that there is a capacity certificate that backstates when the mental health condition arose, that they should do more than they are compelled to do in a way that could be discriminatory and cut across the obligations professionally. And so that is why it is so essential that the process by which the Ombudsman came to her conclusion has to be correct and has to be viewed within the legal context of the Mental Capacity Act.
Okay, so that's what you say about ground 2.
Yes.
You dealt with ground 3.
Yes.
You dealt with ground 4 at the outset.
Yes. Are there any particular matters that I can assist, my lord?
No, no. Thank you very much. Let me just sort of, yes, no. Thank you very much, Mr. Linfield. We don't have anything else. Thank you. Yes, Mr. Cosman. Any reply?
Well, very short. Happily, there seems to be no dispute about the law. So
Madam?
there seems to be no dispute about the law. So I can move on to grounds 1 to 3. I'm not going to return to ground 4. There are 4 short headings. In fact, there are 4. I hope we too formidable. The first concerns responses to the court's questions. The second, the unpleaded reasons challenge. The third, ground 3, and the fourth, contemporaneous documents. In relation to the court's questions, I note 4 and the responses to them, which I say bear on the issues in the case. Honourable Justice Baker asked whether my learned friend accepted there are risk factors present at the outset that may have indicated vulnerability or lack of capacity, to which she said yes. And we say that acceptance demonstrates that the Ombudsman's decision cannot be regarded as irrational, given the basis upon which it was made. The second question, again, of my Lord Justice Baker, was that many family law practitioners will have clients presented in a similar way to this particular interested party, to which we say, I'll go to an to paragraph 33b Roman 1 deals with this.
Sorry, paragraph
33b Roman 1. The professional guidance is not diluted in situations of urgency, and it certainly cannot be irrational. The Ombudsman should have found to the contrary, i.e. the standard applies in a normal way in situations of urgency, and she was plainly aware of the urgency. The third point concerns whether the presumption of capacity absolves solicitors of the responsibilities set out in the Law Society guidance, where there are indicators present from the outset. And my learned friend was asked, why is it irrational for the Ombudsman to perform the effective duty she did? To which the answer was that the Ombudsman elided mental illness and capacity. But that's plainly not her reasoning. And Lord Justice Holgate asked the question, if the solicitor doesn't pursue capacity issues in this situation, who does? And that's obviously an observation which we say bears heavily and demonstrates the decision of the Ombudsman to have been rational. The final point is Lord Justice Holgate's observation about the quote from paragraph 1.14 or 1.14 of the revised provisional decision at paragraph 77 of the judgment. It does end abruptly were to continue, the point that my learned friend makes, the core submission about the elision of capacity and mental health, is addressed, we say, in a proper fashion by the Ombudsman. Moving then to the unpleaded reasons challenge. No reason challenge was pleaded at any stage. My learned friend placed some emphasis on what happened at the adjourned hearing on the 6th of March. The short point is no amendment was made at that point. It could have been, it wasn't, so we're not confronted with a reasons challenge. And to the extent that it is being said that paragraphs 72 to 78 of the judgment, individually or collectively, mean that someone in the Ombudsman's position could not rationally have found an adequate assessment required, we say two things. Firstly, the Ombudsman, as I took you to this morning, plainly did have most of those factors in mind, save the ones which are based on the conclusion she never reached, namely that mental health equals capacity. And in those circumstances, secondly, the criticism of the reasons by the judge below do not rise to a level of rationality, and the absence of a pleaded reason challenge, therefore those points fall away. The third issue, ground 3, there was discussion about the status of the first couple of sentences of paragraph 79, where the judge found that his capacity report rationally bore the conclusion of the Ombudsman that the interested party lacked capacity from the outset of the instruction. That, of course, was a matter which the cross appeal had extended to, and the cross appeal was refused. So we can't stray into that route.
But is it right that 79 was added following a request to the judge on receipt of the draft?
Well, there was an Emery-Reinbold situation that we were confronted with, which was that one of the issues on the list of issues, which was about whether the capacity finding was rational, hadn't been addressed. We wrote to the court produced paragraph 79. But to the extent it said that that process somehow colours or shapes the content of a public judgment, we can't see really how it does.
No, I mean, as a matter of practice, draft judgments are not an opportunity to re-argue the case.
Well, I entirely agree, and the point was put, should you need it, just to see the email, my learned friend was anxious it was included in the further supplementary bundle.
Oh yeah.
And you can find
that's the email.
Page 62, and you'll have seen it was very far from you pushing the point.
62.
Page 62, tab 8.
Mine only goes up to 6, I'm afraid.
So I can hand up a copy.
Does yours go to 8?
Page 62 of the supplemental budget.
It's all right. I'll share my lords. He's got.
Sure, I've got one.
You've got tab 8.
Yeah, I have got tab 8. Yeah. Unpaginated there.
I think
I think I've got a spare copy.
2 copies of this
Mine.
My lord, I'm not quite sure that any of this really need to detain us, but you have the email.
No. I just
Give you comfort.
wanted to.
That the Emery-Reinbold principle was raised in the appropriate way. As with every email chain, you need to go to the end to read it and then read back.
It's on 63. Really.
So 63, I apologise, is where you find the body of mine.
So I haven't got page numbers. This is in Miss,
The
your email.
penultimate page of the
Okay.
very far from the full story. So an open invitation to address it should be judged to the we made a finding that that the Ombudsman's conclusion based on the capacity report was rational. And there you are with that. Save, I just want to address one point. The judge in the following sentence, paragraph 78, appears to have treated the first of the 5 complaints of the Ombudsman as somehow bearing on the conclusions reached in relation to the second of the 5 complaints, And we say, short point, that the Ombudsman presented them and reasoned those as different elements of her decision, but independent elements of her decision. So it's perfectly possible, just as a matter of logic, to have an adequate assessment of capacity and a finding of incapacity were that to have been conducted, and vice versa. You can have an inadequate assessment, but actually interested party had capacity. And that distinction displays quite why we say ground 3 is properly made. And then finally, as to the documents, courts noted to the parties repeatedly that the court's role is to determine whether the judge was right to find the Ombudsman's decision was irrational. Our submission, the nature of the whole appeal, is that that finding is infected by various errors of law. My learned friend took you to various contemporaneous documents. I'm not going to go back to them, we're pleased to hear. Save to make 2 points. The first is the attendance notes with the treating psychiatrist at page 20 of the supplementary bundle, for the subject of the number of submissions. We say that attendance note is striking the number.
Page which, sorry?
So page 20 of the supplementary bundle.
Yeah.
That attendance note is striking for the number of indicators referred to and their repetition from the very first attendance note. But by that stage, of course, they were long-lasting, but notwithstanding, and this is the key point, there had been no assessment of capacity requested in the context of the instruction by the interested party of the respondent. The only way that capacity comes to be assessed is in the family law proceedings, pursuant to an audit in those proceedings. But the interested party's capacity is not assessed independently vis-a-vis the respondent's instruction. And then the final point, my learned friend, referring to the report of Dr. Isaac dated the 12th of November 2020, page 27 of the supplementary bundle,
Yeah.
said that that sounded the alarm about capacity. And we say that's an unsustainable submission. The Ombudsman properly and rationally formed the view the alarm had been sounded on day 1. Unless I can assist further, there's my submission by way of reply.
Right. Thank you both very much for getting through the submissions. We will reserve our judgments. When you get them, they will be in draft form, but that is only so that you can comment on our typographical errors and our grammar. It is not an opportunity to re-argue the case. The judgment will be in draft, so it will be covered by the embargo. And if it hasn't already been done, please ensure that a limited list of the people who can see the draft has been provided to my clerk. He usually does that before, but just in case he hasn't, can you make sure that that goes to him? Once you've got the draft, we hope you'll be able to agree an order in consequence. If you can't, then the thing to do is to prepare a draft order with the conflicting bits, the bits you don't agree, shown in red, and we will accept very short written submissions in support of the competing cases for the bits in red. We will then hope to decide those points so that the order can be handed down effectively at the same time as the judgment, and there will be no need for anybody to attend court for the handing down. That will be electronic. All right, thank you all very much.
Court rise in favour.
I'm just going to give you a list of people that can see that we think should see the judgment. So you,
Presumably the interested party allowed to see the draft.
I'm just going to give you a list from my end so then you can have